Today, we have the unique opportunity to engage in thoughtful and important dialogue with some of the sharpest minds in the field. I encourage all of you, whether you are a student, a scholar, professor, or practitioner, to approach these discussions with an open mind and a critical lens. I hope for this symposium to not affirm preconceptions, but to instead challenge and refine our understanding of such issues. On that note, I would like to first extend my gratitude to our esteemed speakers. Their scholarship and insights have shaped the conversation on executive power, and we are incredibly fortunate to have them here with us today. Before we begin, I would also like to take a moment to express my sincerest thanks to those who made this event possible. Professor Pushaw and Professor Johnson, your guidance and insight throughout this process has been invaluable, and I truly mean it when I say I could not have done this without you, so thank you so much. I want to also thank all of the Pepperdine Law Review for entrusting me with this role with the utmost confidence, and to our editor-in-chief, Jacqueline Kessel, who's sitting right over there. Her leadership has been both inspiring and instrumental in guiding our journal. On the logistical side of things, I would like to thank our events team, Carmen Herring, Frank Vasquez, and Ryan Hemphill, for all of their monumental assistance in coordinating every last detail behind this event. And I really will miss our weekly Zoom meetings. I would also like to thank my friends and my family for their unwavering support, not just throughout planning this event, but throughout my entire journey in law school. Their encouragement, patience, and belief in me has meant the world, and I wouldn't be here without them. And of course, thank you to all of you for being here today, whether in person or virtually, to engage in these important discussions. With that, it is my pleasure to introduce James Blackburn, the incoming alumni and sponsorship editor, who will present the inaugural Pepperdine Law Review Alumni Award. Thank you.
Good morning, everybody. My name is James Blackburn, and I'm the Alumni and Sponsorship Editor. And today I'll be presenting the Pepperdine Law Review Alumni Award for the very first time. The Pepperdine Law Review Alumni Award was implemented by Volume 52 to recognize alumni who have gone above and beyond to support the current members of Pepperdine Law Review. This year, the inaugural Pepperdine Law Review Alumni Award is going to be presented to Dean Stephen White of Volume 52 for his commitment to uplifting Pepperdine Law Review members. I personally didn't get to have Dean White as a professor in 1L, but he was one of the first professors that I had heard all my friends talk about consistently. They talked about how kind he was and how welcoming he was, how he had everybody fill out a form before the first day, and he took the time to memorize the fun facts on those forms so that he could connect with the students on the very first day. For Law Review, he has also helped many members get jobs and clerkships, and more importantly, he has always been there for moral support. He is somebody that we can all rely on. Thank you so much, Dean White.
This is great. I feel like I just won an Oscar or something. This is wonderful. I'll speak briefly. I know you're not here to hear from me today, but I'll just say three things that the Pepperdine Law Review taught me, impressed upon me, and I'm mainly speaking to the students here because I want you to know this as you move forward. The first is attention to detail. I mean, that's what Law Review teaches you, right? Yeah, you blue book, you subcheck, you do all that. But it's because nuance matters, and if you can be trusted in the little things, you can be trusted in the big things. And when you work for a judge, when you work for a partner, when you work at in academia, whatever it is, that matters. So that teaches you that. The second thing is professional excellence. It really does. It teaches you the first bounds of leadership, lessons in failure in leadership, lessons in how to lead well, all of those things, how to deal with your superiors, other professors you're working with. It's a lot of great things. And the third thing, and the most important thing it taught me, is the power of coffee. I really mean that. So as the business and production editor, I was in charge of coffee. And I realized that whoever I could give coffee to, and the coffee decisions I made, and if I got chai tea lattes or whatever, really made people happy or sad. So if you have the power over coffee in your careers, you'll be a powerful person. But anyway, thank you so much, and I'm looking forward to the event today. Thank you.
Good morning, everyone. My name is Paul Cameron. I'm the Dean of our law school, and I had written some remarks here, but our students and our faculty have kind of stolen everything I was going to say. And what I would like to say is just a couple of words about our students here and our law review. We as a faculty are so proud of the work that you do, and we are so proud that you've gathered all of these great folks here. And so I just want to wish you all a great day, and thank you to our law review, to our faculty, and to all of you. Thank you very much.
Good morning. I'm the last one before the first panel, I promise. My name is Joel Johnson. I'm a professor here, a law professor here, and the faculty advisor to the Pepperdine Law Review. And I get the privilege of introducing the panels today, starting with our first panel, which is called Executive Power in the Courts, a New Era of Presidential Control, ? Our moderator is our very own Barry McDonald, professor of law here at Pepperdine, and his research focuses on various issues related to constitutional law. Before I turn it over to Professor McDonald and the panel, there will be time at the end of this panel and all panels today for questions from the audience, so please be thinking of those. You may submit written questions at any point using one of the QR codes that are near you or in front of you. That's the preferred method of submitting questions, but if that's too difficult for some reason, or you're just opposed to QR codes, we will also accept questions the old-fashioned way. You may raise your hand during the Q&A period, and we'll be sure to address those questions. We welcome questions, so please be thinking of them. Without further ado, Professor McDonald to introduce the first panel.
Well, thank you, Joel. I'll introduce our distinguished panelists in the order in which they're going to speak. Marty, you're going to go first, correct?
Sure.
And then Blake, and then Professor Farber is going to be joining us on Zoom. The weather prevented him from joining us in person. So our first speaker, Marty Lederman, is a professor from practice at Georgetown University Law Center. Prior to joining Georgetown, Marty was a Deputy Assistant Attorney General in the Department of Justice's Office of Legal Counsel from 2009 to 2010, and an attorney advisor in OLC from 1994 to 2002. From 1988 to 2004, he was an attorney at Bredhoff and Kaiser, where his practice consisted principally of federal litigation, including appeals on behalf of labor unions, employees, and pension funds. In 2008, with David Barron, he published a short two-part article in the Harvard Law Review examining...
That's that short 300.
Yeah, I don't know, yeah. I don't know where that came. In the Harvard Law Review examining Congress's authority to regulate the commander-in-chief's conduct of war. Prior to rejoining the Department of Justice, he was a regular contributor to several blogs and websites, including Balkanization, SCOTUS blog, Opinio Juris, and Slate, writing principally on issues relating to separation of powers, war powers, torture, detention, interrogation, international law, treaties, executive branch lawyering, statutory interpretation, and the First Amendment. Wow, that's a long list of topics. He served as a law clerk to Chief Judge Jack B. Weinstein on the United States District Court for the Eastern District of New York, and to Judge Frank M. Coffin on the United States Court of Appeals for the First Circuit. Please welcome Professor Lederman. Our next speaker will be Professor Blake Emerson. Professor Emerson is Professor of Law and a Professor of Political Science at the UCLA Law School. Prior to joining UCLA Law, he was a research fellow at the Administrative Conference of the United States in Washington, D.C. His primary research interests lie in administrative law, structural constitutional law, and political theory. In 2021, he received the Association of American Law Schools Administrative Law Section's Emerging Scholar Award. In spring of 2024, he was a visiting professor of law at Yale Law School. Professor Emerson's research examines the normative and historical foundations of American public law. He draws on resources from political theory and American political development to understand the structure and purpose of the regulatory state. He studies questions such as what role have federal government agencies played in interpreting and implementing civil rights and other fundamental public values? How can legal doctrine ensure that agencies address such significant policy issues in a reasoned and inclusive fashion? In what ways have the diverse institutions of the American state realized or failed to live up to democratic principles? Professor Emerson received his BA magna cum laude with highest honors from Williams College, his PhD with honors from Yale University, and his JD with honors from Yale Law School. Please welcome Professor Emerson. And joining us online will be Professor Dan Farber, is the Show Sato Professor of Law at the University of California at Berkeley. He also has leadership roles at two Berkeley research centers, the Center for Law, Energy, and Environment, and the Edley Center on Law and Democracy. Professor Farber is a member of the American Academy of Arts. Professor Farber is a graduate of the University of Illinois, where he earned his BA, MA, and JD degrees. He graduated summa cum laude from the College of Law, where he was the class valedictorian and served as editor-in-chief of the University of Illinois Law Review. After law school, he was a law clerk for Judge Philip W. Tone of the U.S. Court of Appeals for the Seventh Circuit, and then for Justice John Paul Stevens of the U.S. Supreme Court. Professor Farber practiced law with Sidley and Austin, where he primarily worked on energy issues before returning to the University of Illinois as a faculty member in 1978. He taught at the University of Minnesota Law School faculty from 1981 to 2002, where he was the McKnight Presidential Professor of Public Law. He also has been a visiting professor at the Stanford Law School, Harvard Law School, and the University of Chicago Law School. Please welcome Professor Farber. And without further ado, Professor Lederman.
Thanks very much, Barry. It's really an honor to be here and a pleasure to be out here and in between the wildfires and the floods and the like, and navigating the highway, the long way. It's really delightful to be here with such a wonderful group of folks to talk about really pressing issues that really, my remarks have been changing by the day, really, because of events that have been going on. And I'm going to talk in our panel, roughly speak, we'll talk, among other things, about something that's been called the unitary executive theory. And I'm going to assume that most of the students and scholars in the room and online have a rough idea of what that means, but to discuss why it's particularly an acute question now, and what the implications of it are now, because I think it's never been more important, both because of what the Supreme Court has done with it and what the new president is trying to do with it and might be permitted to do by the current Supreme Court. So I figured I'd break this up sort of just to set it up, just sort of past, present, and future. So in the past, the issue is, roughly speaking, whether Congress can, in its structuring of the executive branch, whether Congress can provide that certain actors other than the president, department heads, commissions, and the like, are entitled to exercise statutory authorities, not the president's constitutional authorities, but statutory authorities with some degree of independence. Certainly, those officials are typically appointed by the president in power, and usually they are their views pretty much track the president's. But they're supposed to be making decisions on their own, and sometimes pursuant to quite broad delegations of authority, giving them some discretion or some expertise or a mandate to apply facts to law and to adjudicate things clearly. And Congress has been doing, since the very first Congress, these sorts of assignments have been made to department heads and to other officers in the United States government. And the question is, to what extent can Congress insulate their decision-making from presidential control? roughly speaking, and they can do that in several different ways. One is simply to assign functions to them that they have to perform with an implied limitation, at least this was the historical account, an implied limitation on anyone else being able to perform those functions or from directing them about how to perform them, including the president, or to give them express independence. There are many modern statutes saying that particular agencies have some degree of independence and shall act independently, and or to protect them through what are called tenure protections, saying that it can only be removed for cause or for inefficiency, neglect of business, malfeasance, and the like. So various different statutes written in various different ways over time. I want to be clear at the outset that there's a common understanding, and I don't think much of a dispute, that the president has to have the authority and Congress has to give him or her the authority to make sure that those officers comply with the law, that they are acting within their legal authority, that they are not violating the law, that they are not themselves acting with malfeasance or improperly. And that has been the basic structure of the way this question had been addressed and understood for most of American history. What is necessary to give the president sufficient power and authority to make sure that the other officers are complying with their statutory mandates and their statutory powers in a lawful way and a proper way. And as long as Congress gave at least that much to the president, that was all that Article 2 of the Constitution was understood to require. And that was where the debates were. Does the president have enough authority to do that? Going right up until about 2010, when Chief Justice Roberts wrote an opinion about dual layer removal authority. The structure of his opinion was whether the president had sufficient control to make sure that a board 2 steps down from him would act in compliance with law. Would he be able to, in other words, would he be able to take care the laws are faithfully executed, as Article 2 directs imposes that duty on the president? Would he be able to do that? Beginning in the 1980s, some scholars, particularly Steve Calabresi, Sai Prakash, and others, began, along with the Justice Department, Charles Freed and Ed Mead's Justice Department, to take a more aggressive view of the unitary executive and to suggest that the vesting clause of Article 2, that's the simple first sentence of Article 2 that says that the executive power of the United States shall be vested in a president of the United States, that the vesting clause itself actually gives the entire power to execute statutes, not just constitutional authorities, but statutes to the President of the United States, that he or she can exercise himself, right? That Congress can't take away that power. That gives him complete power to direct the officials who are given those authorities and gives him the power to remove them at will. That this is a power that the Constitution guarantees to the president, to this one individual, and therefore he or she must be able to control everything that goes on in the executive branch, up to and including performing the functions him or herself if they're not satisfied with the way that others are doing it. Now, in 1838, a unanimous Supreme Court described this as an alarming doctrine and unanimously said that it was ridiculous. It didn't describe our practices at that time, and it didn't. Attorneys general of various different kinds, and I should add that was a somewhat outdated, I should have given you guys an updated bio. I worked for the Biden administration, Justice Department, for the first 30 months of the Biden administration. I've had 3 stints. I'm a presidential power guy. I believe in strong presidents. But this doctrine, this idea that the vesting clause gives the president this authority to basically perform all statutory functions, even if Congress has said that others should have them, was an alarming doctrine that was rejected unanimously very early in the Republic and repeatedly rejected by the Supreme Court, usually by unanimous votes in cases such as Humphrey's Executor, the Weiner case, which I'll talk a little bit more about because it's particularly important now in the 1950s. And then in the 1980s, when the Reagan administration sort of gingerly tried to raise this before the Supreme Court, Justices O'Connor and Rehnquist basically told them at oral arguments, this is ridiculous. And in a footnote in Morrison versus Olson, Chief Justice Rehnquist wrote that it's an extrapolation from constitutional language that is more than the text will bear. And so it was just like rejected in a footnote with one dissenting view, that being Justice Scalia's, who basically adopted this theory alone. And that's now become the law of the land. In a case called Saylor Law several years ago, at least in the rhetoric of Chief Justice Roberts's opinion, he seemed to adopt hook, line, and sinker this very, very strong idea of a unitary executive on the following grounds. He wrote, under our Constitution, the executive power, all of it, is vested in a president. And because the only reason we have other officials in the executive branch is because no one person could fulfill that responsibility. And so the framers expected the president would rely on subordinate officers for assistance. They would be his agents who wield executive power in his stead and on his behalf. And it followed from that, according to the court, at least in that case, that the president had to be able to control, in that case, the Consumer Financial Protection Board, and to remove at will its single-headed, the person who was the single head of that board. Now, the holding in that case only went that far, that it's a fairly modern innovation that the single-member heads of these agencies who wield great significant power to regulate the economy and other things, the president has to have at-will removal authority to remove them. The chief reserved the question of multi-member boards, which has been the norm in the 20th and 21st century, of creating these sorts of independent agencies who are supposed to be somewhat removed from partisan and political control, but read those precedents quite narrowly. The silver lining was that he suggested that if Congress just made the CFPB a multi-member agency, it would be okay. They would be able to retain their tenure protection, but he didn't quite hold that. It was only a suggestion. And the rhetoric of this opinion has now been, today's word of the day, right, word of the year, weaponized by the Trump administration in various respects to assert an extraordinary power over the executive branch in many respects. And first of all, he's issued an executive order saying that the independent regulatory agencies have to basically get the approval of the White House, of OMB and the president, in order to issue any regulations, that they are subject to his control. And because all the executive power is vested in him, they must be supervised and controlled by the people's elected president, that he has, quote, control of the entire executive branch. And as most of you know, he has removed many, many officials who Congress has said cannot be removed at will. He has said that all those statutes are unconstitutional. And here I want to sort of break, and this is going to be way oversimplified, but Congress gives actors in the executive branch some independence from politics and from presidential control for roughly two basic reasons. It's way more complicated than that. One is that there's certain functions of regulating the world in which you don't want politics to play a part because Congress has reasonably thought it would be a disaster. The most obvious one being the monetary policy of the Federal Reserve, but also the Federal Election Commission, the FCC. There are places where you think politics will distort in ways that are dangerous, and you don't want that. But most of the agencies and officers that President Trump thus far has tried to control are those within the executive branch whose job is to keep the executive branch acting lawfully, right? That's the key move here, that this is part of something much broader than just the unitary executive debate. This is part of an effort by President Trump to get rid of any agency within the government or outside it, and we'll have plenty of time to talk all day today about the various moves, to make him basically king-like and not subject to any checks in terms of law, policy debate, people taking issue with what he might think and the like. And it's happening in area after area after area. So the people he's removing are the special counsel who's supposed to make sure that the internal executive branch does not punish people for partisan reasons or punish whistleblowers improperly. The Merit Systems Protection Board, which is supposed to adjudicate the fairness, whether civil servants have been fired lawfully. Just yesterday, Judge Suknanan overturned or enjoined the removal of a member of the Federal Labor Relations Board, which is supposed to make sure that federal contracts are honored. And the inspectors general are not subject to any tenure protection by Congress, but he fired a bunch of them too, because they are the people looking into whether the government is acting lawfully. And it's not just the removals, it's within the Justice Department. He has removed anyone who ever did anything that he thinks was contrary to his interests. He has had his Attorney General issue an extraordinary memo on her first day in office, telling Department of Justice attorneys that they have to file and sign briefs and make arguments in their own names, even where they don't believe it, because their job, she says, the job of the executive branch is to exist to carry out the president's policies, not Congress's, not the United States, but the president's. This, in addition to all of the steps the president is taking to try to suppress dissent and to get people to heal in higher education. Think of what happened at Columbia yesterday, which is certainly the greatest threat to the independence of higher education in my lifetime, what we're about to be going through. What he's doing with the press, with members of the Republican Congress who are basically told that if they don't do his bidding, the best case scenario is that they'll lose their jobs, which is true. He is using every lever of government power to try not only to get his policies enacted and performed, that's one thing, that's sort of the classic unitary executive idea, but to make sure that no one can take issue with anything that he does, that legal constraints are not applied. Just yesterday in the Supreme Court, the acting Solicitor General, in asking for the birthright citizenship order to be allowed to go into place as to non-parties, had to make an argument about what the equities would be without making any claim that the president's order was lawful. And basically it was, you're getting in the way of President Trump's policies, and therefore, even if they're unlawful, we should allow them to continue in practice. In the MSPB case in the DC Circuit, he is now, their briefs are going in now and saying that the damage, that they are suffering irreparable damage. What is the evidence of that? That the MSPB is actually issuing orders saying that certain people were dismissed unlawfully, right, within the Agriculture Department. In other words, they're being very candid and forthright that simply taking issue with something that the president and the president's appointees want to do and adjudicating whether that is lawful or not, or giving legal advice in the Justice Department about whether that is lawful or not, is something that he cannot countenance and ought not to have to put up with. That everyone should fall in line, both in civil society and within the executive branch. This is an extraordinary thing. So let me turn, I probably just have a few minutes, right, left? 3 minutes left. So what's going to happen? There are 3 cases in the DC Circuit, going up to the DC Circuit right now, in which district courts have enjoined the removal. The MSPB that I mentioned, the Federal Labor Relations, and a member of the National Labor Relations Board. One or more of those 3, perhaps all 3, will get to the Supreme Court very soon. Will the Supreme Court go the route that John Roberts spelled out in Sailor Law and say that the president has the power to remove all those officials? It's very possible. I also think it's possible that the court might distinguish and might say that when it comes to the internal actors, those who are whose job is to keep the executive branch performing according to law internally, there's supposed to be checks on illegality within the executive branch. Congress can provide some sort of protection and independence for them. I hope they will go at least that far. And then I guess we all have plenty of time to talk about any and all of these issues, but I did want to suggest that if the court does sort of keep going this way, and President Trump is allowed to take this extraordinary and really unprecedented control over the executive branch and suppress all dissenting views and debate, we need to start thinking about what the world looks like. We can complain about that all we want and write law review articles about it all we want. But if and when Democrats get back into power, and maybe this is just hypothetical at this point, what do we do with this, right? The inclination has been very much in administrations like the Obama and Biden administrations to adhere to these norms, what I was calling the historical view of things, and to really believe in these proceduralist constraints and these procedural norms in which government lawyers and government officials are debating and adjudicating the law within the executive branch. And when what really cares about the civil service and the civil service norms that we had developed over years, those have been blown to smithereens in the course of 6 weeks. And it's not clear to me that the other side's ever going to win elections on on return to proceduralism. That's not how it's going to work. And I think there's real questions if John Roberts and Donald Trump build this edifice of extraordinary presidential control, there's a lot of thinking to be done and debate to be had about what the response to that should be if that's what the future looks like. And I'll be honest with you, I don't know what that ought to look like. And I don't have any strong views on it, but it's something that we have to start considering. But in the short term, I think right now the challenge is going to be before the Supreme Court as to whether they'll go forward with this alarming doctrine that had been rejected for 200 years, or whether they're going to put some sort of stop on it now that they see how it can be used by a president that really wants to be unitary in the strongest possible way.
Thank you, Professor Lederman. Professor Emerson?
Great. Thank you so much. So first of all, I just wanted to thank Matthew and Jacqueline, the Pepperdine Law Review, for organizing this great event, as well as to Professor Johnson for his role as faculty advisor. It's really great to be here to speak on these. Thank you. These really momentous events. And so what I want to do is, first of all, just basically co-sign everything that Professor Lederman just said in his diagnosis of the unitary executive. I agree in full. And the question that I want to think about and raise is how this unitary executive theory relates to a different set of developments at the Supreme Court that are restructuring administrative law and taking away administrative lawmaking and adjudicatory powers that in some ways complement, but in other ways constrain the president's authority. So if you think about what makes an administrative agency in the United States, if you think about what is characteristic of all agencies, from the Environmental Protection Agency to the Securities and Exchange Commission, even to the Merit Systems Protection Board, I would say it is the independent authority to act with legally binding force. So there are a couple pieces to that definition. So the independent authority piece, as Professor Lederman noted, it's not the case that every administrative agency is formally independent from the president. In many cases, the heads of the agency are removable by the president at will. That's true of the EPA, it's true of the Treasury, the Justice Department. Nonetheless, if you look further down the hierarchy into the civil service, in every agency, at least within the domestic regulatory space, the subordinate employees enjoy for-cause removal protections, which means that when they're rendering their judgment about questions of law or questions of policy, questions of scientific judgment involved in regulation, they can do that and arguably must do that without being directed by the president or by a political official. And that guarantees a degree of impartiality, of reasoned judgment, and of developing a factual record to test what the government does when it gets reviewed. So you get this architecture of legality, of the rule of law, and reasoned decision-making within the executive branch. So that's the independence prong of administrative agencies and the administrative state. And then the other piece, and so the unitary executive theory that's now in full vigor, I would say, and maybe even going beyond its wildest ambitions at the moment,
it strikes at that independence prong, because taken to its full extreme, the entire civil service system that has existed since the 1880s is unconstitutional. So that's prong number one. But now there are two other prongs I want to talk about. The second is a set of cases that deprive agencies of the ability to make policy in various ways, characteristically by issuing rules that have the force of law. Right? And so agencies like the EPA can issue regulations to reduce pollution, and these rules have equal legal force to a statute enacted by Congress, although they are, of course, judicially reviewable. And in a set of cases, the court has struck at agencies' power to do that. So, for instance, in the Loper-Bright case, which gets rid of Chevron deference, it doesn't say that agencies can't make rules, but it says that those rules don't deserve deference from the courts. And what that means is that those rules don't have the force of law in the sense they used to. Because one element of a rule having the force of law is that if it is within the bounds of the statute and it's reasonable, then the courts must accept it, even if they would not have interpreted the statute the same way. So Loper-Bright takes away a key element of rules binding legal force. The major questions doctrine says that agencies cannot enact policies of vast economic or political significance without explicit authority. That too significantly shrinks agencies' policymaking power. We've seen that applied during the COVID-19 pandemic. We've seen that applied in the context of climate change regulation. And so if you ask someone like Justice Thomas what he thinks the non-delegation doctrine requires, Justice Thomas thinks that agencies cannot write regulations at all if they affect private parties and if they impact private rights. And Justice Gorsuch, in a slightly lighter register, thinks that agencies cannot make policy decisions. And so if you look at that overall set of holdings and the trajectory of the case law, there seems to be an effort to deprive agencies, and there is an effort, to deprive agencies of their capacity to act with the force of law. Now, I'll just flag, you might think that that is a bit of a security provided to the developments that Professor Letterman's talking about, in that, well, yes, maybe the president has all of the executive power, but maybe the executive power is no longer so great. Maybe the executive no longer has the same authority to act with the force of law. But I want to just flag that, and I'll come back to that in a moment. So the third prong of binding powers, independent powers that agencies hold, is their power to adjudicate cases involving private rights. So think, for example, of the Securities and Exchange Commission has its own administrative tribunals, in which an administrative law judge presides over matters such as securities violations, securities fraud. And there's long been a line of scholarship developed by scholars like William Bode and Caleb Nelson that suggests that agencies' long existing authority to adjudicate such private rights is unconstitutional, because only the Article III courts are permitted to adjudicate those kinds of rights. And the Supreme Court has recently taken up that invitation in Securities and Exchange Commission versus Jarkazi to a partial extent. And it said that at least when it comes to imposing civil penalties for a common law type cause of action, it's unconstitutional for the agency to adjudicate it, because that violates the Seventh Amendment right to a jury trial. Right? So we now have a strand of precedent that says agencies cannot adjudicate at least some class of private rights concerning market regulation. And what you see in that case, in Jarkazi, you see kind of a revival of a Lochner kind of theory of the limits of governmental regulation, where Chief Justice Roberts says that the SEC is not permitted to adjudicate contracts that arise out of a pre-existing market. So there's some kind of a natural right, it seems, to engage in securities transactions. Okay, so put this all together. We have the unitary executive theory that says the president has all the executive power. Taken to its full extreme, the civil service is unconstitutional. We then have another trajectory of case law that says agencies can't make binding rules that settle significant questions of policy. And then the third prong, agencies cannot finally adjudicate at least questions of fact with regards to private rights in matters such as securities regulation or unfair trade practices or labor disputes, you name it. So where does this leave us altogether? As I suggested a moment ago, you could see this in a kind of silver lining way that, well, perhaps it's a bit of a security that if the president has all of the executive power, but we've shrunk the executive power by taking away these binding authorities, then the residual executive power the president has is not so worrisome. And I think that's matters are at a minimum much more complicated than that, because one of the important effects of giving agencies binding authorities is to constrain the ambit of the executive's discretion when it sets out to enforce the law, because it's a black letter principle of administrative law that agency regulations have the force of law, which means that an agency can't act contrary to a rule as long as it's in force, even if the president would like them to, right? So a principle that was enforced most famously against President Nixon when the Justice Department subpoenaed records related to the Watergate scandal. So what these regulations do is that they specify the agency's authority so that the agency is not able to arbitrarily enforce statutes that are often written in such a broad way that the agency would have truly wild discretion in the absence of the agency's regulations that specify what those authorities require. So if you think about statutes that say for the FCC, whatever the public interest, convenience, or necessity requires with regards to the regulation of telecommunications, without further regulations specifying what that means, it seems like it could mean almost anything. And it might mean, for instance, seems to be going on now, taking reprisals against political opponents in news broadcasts. Likewise, adjudicatory constraints are significant in areas such as immigration adjudication or Social Security disability hearings, where the precedent of the agency constrains how particular cases are decided in hundreds of thousands of cases that affect citizens or non-citizens in the case of many immigration cases. So that's just to emphasize that the dismantling of administrative law and the administrative state, in some ways, you could argue that it diminishes presidential power, but in many other ways, it simply enables and facilitates it by taking away internal constraints and clarifications that administrative law supplies within the executive branch and the way it impacts citizens and other private parties. Okay, so where does this leave us? What is the future of the executive branch in this context? Well, I think nice is the wrong word, but an example of what you might be seeing is the Columbia case, where a number of agencies, most centrally the Department of Education and the Department of Health and Human Services, have said that they are immediately canceling $400 million in grants to Columbia on the supposed ground that they have not complied with Title VI of the Civil Rights Act with regards to the pro-Palestinian protests and the treatment of Jewish students. Now, the statute is quite clear about the circumstances under which that can be done. The funds can only be taken away after what's called a formal adjudication under the Administrative Procedure Act, which is an adjudication in front of an administrative law judge. And then that would be followed by a right to seek judicial review in an Article III court. It also requires reports to Congress, and then the funds can only be taken away 30 days after those reports are entered in. And so what we've seen instead, though, is the Trump administration simply asserting the power to immediately cancel the funds and threatening what's essentially a kind of civil prosecution of Columbia in the absence of any of those procedural steps. And so I think that's an example of the kind of arbitrary authority that you're likely to see a lot more of as executive power grows and administrative constraints get stripped, which is that executive agencies at the behest of the White House simply pick and choose who they would like to bring enforcement actions against without any constraint provided by the agency's precedent or its internal regulations. You can also, another area where I might have worries about that would be in the antitrust space, where the Federal Trade Commission and the Department of Justice might wield that authority, say, against the competitors to Elon Musk. So that's, I would say that what we're seeing is a shift to an executive branch that has traditionally, at least over the past 150 years or so, relied on adjudication and later rulemaking to constrain the exercise of executive power, to one that's really dominated by enforcement actions on the model of prosecution, where vast coercive pressure is brought to bear without any kind of procedural constraint within the executive branch itself. Now, how might one respond if you were worried about those kinds of developments, as I am, and as I think we all should be? There's no other route, I don't think, except for Congress to get in the game. There are a number of things that Congress could do within the bounds of the Constitution to respond to these sets of developments. It could, for instance, make administrative law judges appointed by Article III courts, which would remove the kind of unitary executive concerns that the court has expressed about multiple layers of for-cause removal protection. And there are many other examples I can go through if you're curious in Q&A, but Congress must act. Otherwise, Congress is simply acquiescing in a new state of affairs where the president is exercising extra legal power. And then we end up with a historical gloss where the president has become some kind of a king.
Thank you, Professor Emerson. Professor Farber?
Hi, thank you. I'm really sorry I can't be there in person. Not only because it always feels a little detached to be giving a lecture over Zoom or a talk, but also because I'm missing the opportunity to get to talk with all of the participants and learn a lot. But I've already learned a lot from the presentations this morning. So in a sense, I think what I have to say is kind of a counterpoint to the last presentation. I'm taking a little bit of a different approach, and I think that's partly because I read some of the cases a little differently, but I think we have some similar concerns. So what I want to talk about are clashing visions of executive discretion, and the clash, as I see it, is between the Supreme Court and Trump, and we'll see how that all develops, but I'll try to lead you to that perspective. I've spent a lot of time reading Trump's executive orders, partly because a number of them intersect with my other areas of expertise, and partly because they have such broad repercussions. And it's been an interesting exercise. The picture that the executive orders convey is that there are some hard limits on agencies, things that statutes unambiguously either prohibit or at least fail to authorize. But within those limits, the executive order really treats agencies as completely free to make policy on whatever basis they want. And if you combine that with the unitary executive, that means on whatever basis the president wants. This corresponds in a way, ironically, to a somewhat simplistic, some might say caricatured view of the Chevron doctrine as granting open-ended discretion except where unmistakably contravened by statutory language. And so I think the real question is, in the regulatory space in particular, is about who takes the lead in US policy and to what extent the executive branch is free to engage in sort of its own creative exercises that are detached from the underlying statute. In a sense, I think this is taking what's been called presidential administration to new extremes. We've seen centralization of policy authority within the executive branch accrete to the White House, beginning at least with Ronald Reagan, but really continuing through all the presidents since then. And you can see this as, in a way, accepting the vision that conservatives have had, that agencies are really free to go off on whatever direction they want to. Congress has given them lawmaking authority, and therefore they are basically taking over the legislative function. If you combine that with the unitary executive, what that means is that the president has sort of open-ended policy-making authority and something like legislative authority within whatever hard barriers statutes might impose. So I want to provide some examples of that and then contrast it with the current Supreme Court's view of executive discretion, which I think is more bounded in some important ways. So some of the most notable things that Trump has done relate to funding freezes, and I think these really reflect his view of presidential primacy in policymaking. One of Trump's first executive orders aimed to, I'm quoting now, ensure that no federal funding be employed in a manner contrary to the principles outlined in this executive order unless required by law. Another executive order directs agencies to eliminate school funding for what the president terms gender ideology and discriminatory equity ideology, something that I think would be hard to ground in the statutes themselves, to the maximum extent consistent with applicable law. So applicable law sets some outer limits, but within that, if the president doesn't like gender ideology, the president is free to go after that. There's also been similar kinds of language in executive orders relating to agency regulations. I also work in environmental law, so I was pretty interested in an executive order on energy that had tucked into it some fairly dramatic changes in the way that the government is going to be doing environmental impact statements. Trump called for new regulations by the agencies over their procedures for doing environmental impact statements. And in doing that, he directed that they focus primarily on administrative priorities to the extent not forbidden by law. So here's the language. Consistent with applicable law, all agencies must prioritize efficiency and certainty over any other objectives that do not align with the policy goals set forth in this order. And the order as a whole is about achieving American energy dominance through expanding production and use of fossil fuels. So, basically the idea is that anything that doesn't fit with that has to give way to the goal of speeding up the process and making it work more quickly. And what's interesting here is that these regulations are implementing a statute called the National Environmental Policy Act. But in implementing that statute, again, to the extent legally possible, agencies are supposed to give absolute priority to non-environmental interests wherever possible. And I think clearly the picture here is there's a zone of discretion within that zone of discretion. It's the president who calls the shots. And whatever the statute itself was designed to do kind of falls by the wayside. I think it's fair to ask how different Trump 2. I think this is more extreme than what we saw in the first Trump administration, although it maybe was implicit in some of what he was doing. So how different is this really? As I've said, we've seen uh, uh, increasing centralization within the executive branch um, through, for example, the activities of the um, Office of Information and Regulatory Affairs, OIRA, better known as the Regulatory Czar, and a variety of other White House initiatives, appointments of czars to sort of control and coordinate agency action in different areas. So I don't think you can certainly say that the idea of centralizing policy control in the White House is entirely new. And in the case of cost benefit analysis in OIRA, I think it goes back to Ronald Reagan, and the goal has been to ensure that a uniform policy agenda of economic efficiency is applied across the government, except where that's legally impossible, right? So again, this sort of idea of discretion to uh, set policy more or less independently of statutes whenever there's agency discretion. But what we're doing today is seeing a combination of this sort of trend towards presidential administration with the idea of a unitary executive that leaves less and less room for policymaking judgments below the White House level. In effect, I think you could say that under the Trump vision, an official's job is to take care that the president's agenda be faithfully executed. All right, let me turn to the Supreme Court. I'm going to talk about partly the Loper-Bright case, which you've already heard about this morning. Loper-Bright is the case that overruled Chevron, for those of you who don't follow these things as closely as some of us. And the court's opinion is partly about the role of courts versus agencies, but the opinion also embodies a conception of the role, I think, of Congress vis-a-vis the executive branch. When an agency has discretion, the court says, there's really most of the opinion is about overruling Chevron, and there's about a page about what replaces it, and that's one page is really my focus. So the court in Loper-Bright divides the world into sort of two categories, or the world of agency action. There are areas where Congress has given the agency discretion, either explicitly by conveying rulemaking power, or implicitly, sometimes by using broad language that the agency will have to clarify. And in those areas, the court enforces legislative boundaries. So that's, I think, consistent with the Trump vision. But the other thing is that within those boundaries, the courts ensure that the agency has engaged in reasoned decision-making. And the key point here, I think, is that statutory policies don't necessarily vanish when there's discretion. A decision that ignores statutory policies or favors conflicting policies, I think, would be held to be arbitrary and capricious under State Farm and Overton Park. So, for example, I think if an agency in revising its NEPA regulations for environmental impact statements says that they are doing it in the name of efficiency and certainty and increasing fossil fuel production, and they don't say anything about the environmental dimension of what they're proposing, it seems to me that's going to be arbitrary and capricious. So there is some degree of constraint even within areas in which agencies have discretion. Congress doesn't become completely irrelevant there. The second category of cases, according to Loper-Bright, are those where there's no congressional delegation, But the court still says there's some degree of respect or deference for agency views of the meaning of statutes, especially if the agency view is longstanding or involves technical issues. And this is what administrative law people call Skidmore deference. Now, what's interesting is that this is really based on the agency's experience, and it's not something that the president can necessarily piggyback on because it's not the president who has the technical expertise or the practical experience in the day-to-day administration of the statute. For that reason, one of the executive orders basically tells agencies that the judgment of the president or the attorney general is final on all legal issues. And that applies also to independent agencies. But to some extent, that may be counterproductive in terms of the ability to make a claim for Skidmore deference if you're saying the agency is really cut out of the process of interpreting the statute itself. Now, I think there's a similar kind of concern that underlies the major question doctrine. The court said in West Virginia versus EPA that it won't infer a delegation of power to the agency to make decisions of great magnitude because of separation of powers principles and a practical understanding of legislative intent. And the goal clearly is to maintain congressional primacy rather than allowing the executive branch to make the most momentous policy decisions on its own. Interestingly, in West Virginia, Gorsuch expresses concerns not just about agencies, but about presidential power. Gorsuch worried that if the executive branch were allowed too much discretion, in effect, legislation would risk becoming, this quote, nothing more than the will of the current president, or worse yet, the will of unelected officials barely responsive to him. As an aside, I suppose Gorsuch was thinking of bureaucrats, but I'd be thinking of Elon Musk in that setting. He also says, Gorsuch, stability would be lost with vast numbers of laws changing with every new presidential administration. And then finally, Gorsuch complains that rather than embodying a wide social consensus and input from minority voices, which is the way Gorsuch sees Congress, laws would more often bear the support of only of the party currently in power. And I think, although I don't necessarily agree with Gorsuch's views of what we should do with those concerns, but I do think that he seemingly could have been speaking about the current administration. So I'm certainly not the first to observe that Loper-Bright and the major question doctrine are possibly barriers to some of the really huge regulatory or deregulatory moves that Trump wants to make. But my point is a little different. It's that these decisions reflect a very different vision of policymaking, which leaves Congress rather than the president in the driver's seat. The court's conservatives unanimously joined both Loper-Bright and West Virginia. I think a cynic might argue that their emphasis on congressional primacy and on the dangers of executive discretion may have been limited to the dangers of Democratic presidents. Maybe they will do an about face now that Trump is in the White House. But, you know, I would not give up on the idea that they were serious about what they said in those opinions, and that regardless of the extent to which they may want to see the president having ultimate control of the executive branch, they may put a damper on some of the broad claims about executive discretion that we're seeing in the Trump administration. Thanks.
Thank you, Professor Farber. Now let me give the panelists a chance to comment on each other's talks and perhaps probe those a little bit further.
Well, yeah, so just to respond to some of Professor Farber's insights, I do think it's important to take seriously the existing state of Supreme Court case law on issues like judicial deference. And one of and also I particularly think that the major questions doctrine is potentially, if applied even-handedly, is a significant tool in the present moment. I mean, so again, the major questions doctrine says that an executive agency cannot address an issue of vast economic or political significance unless the statute explicitly says that they may. And I would imagine if you applied that principle to many of the actions currently taken by the Trump administration, such as many of these vast firings of federal employees, even if they were arguably compliant with the formal text of the statute, and I'm not saying that they are, but even if they were, they quite obviously raise major questions, and the statute may not explicitly give the president that kind of authority. So for instance, the Civil Service Reform Act from 1978 does give the president the authority to impose regulations with regard to the civil service as quote, the conditions of good administration warrant. And the president has relied on that with regard to the Schedule F executive order that would remove civil service protections for any civil servant who exercises policymaking or policy forming functions. So yes, the president does have a rulemaking power. Does that power include the power to strip about 50,000 civil servants of their currently existing removal protections, which under due process case law are treated as property interests that can only be removed after hearing? Okay, and I think under major questions, the answer to that is probably no. So I think those protections are significant. Nonetheless, I think there's a lot of play in the joints in a case like Loper-Bright, for instance, where the court has created enough ambiguity where discretion persists and may continue to license a lot of executive power. So first of all, as Professor Farber noted, the Loper-Bright doesn't eliminate all forms of deference. Well, we wouldn't call it deference, but all forms of delegation of policymaking power to agencies. And it remains unclear what the difference is between Chevron and allowing the agency to make policy choices within the bounds of a delegated authority. And so the opinion leaves open a set of questions because it's not very clear about what this new approach to judicial review is. And it's not clear how the court will approach issues such as standing in a lot of the cases that we're going to see come up before it. So I think it's a wait and see pattern with regard to how the court will respond to the present moment. But I also just think that there's a limit to what the judiciary can do in this context. I mean, if first of all, if at a minimum, if the Trump administration is not really complying with court orders, it doesn't really matter what the courts say. And I think we're not quite in that situation yet, but we may get there, and that's a question mark. But more fundamentally, the executive branch can act more readily and quickly to simply even if it formally complies with one judgment, it just recreates the action in a different form and does it again. And this is why, if you go back to a case like Ex parte Merriman in the Civil War, where Lincoln suspended the writ of habeas corpus, and Roger Taney said, basically, there's nothing at this point. There's nothing I can do. This is the president is a force too great for me to overcome, and that is kind of, I think, the situation we're in now, where the courts don't have the institutional resources or capacity to respond without Congress co-signing and asserting its authority in the space as well.
Given the time constraint, well, Dan, you want to respond to Blake?
Yeah, I don't really disagree in the sense that I think there clearly is wiggle room. The court could sort of acquiesce in what Trump's doing without necessarily disavowing previous language. I do think that there's a kind of vision of how the executive branch ought to work in those earlier opinions and how it ought to relate to Congress. That I think would lead them to try to constrain some of what Trump's doing. But I don't have a crystal ball, so I think we'll have to see whether um, at least a couple of the conservatives are willing to sort of stick to that vision and pursue it vigorously. I think the question of how the Trump administration would react, we don't know. We obviously have something of a constitutional crisis if Trump just announced he was going to ignore what the courts were doing. Um, and I agree with the larger conclusion that in the end, the courts can't do this alone. I think a lot is going to depend to both whether um, what happens in Congress and also how public opinion might shift in one way or another, in the next months or next couple of years. So I guess the bottom line is I'm a little more optimistic about the Supreme Court, I think, but I don't basically disagree with what Blake just said.
And I guess I think there's so many dubious legal moves that the administration has made just in the first 6 to 7 weeks that the court is going to be inundated with these challenges. I think some of the challenges probably are not good on the law, but have other values as well, just as sort of the increased transparency of what Doge is doing and what role does Elon Musk play in all of that. That's now all coming out just in terms of discovery orders and requiring witnesses to come into court and to explain what they're doing. I mean, one remarkable thing I think is that DOJ lawyers are consistently going into trial court and having not only weren't the policies and the practices vetted with the Justice Department beforehand, but they don't really have any idea what their clients have been doing or what the legal theories were, and they're being sort of retrofitted after the fact. And you can see in the respective briefings that the arguments get better and better, or at least sharper and sharper as the briefings go on. This is really breaking things first and then trying to figure out what the legal arguments are afterwards. And that's another function of this absence of process. And I think it will hurt the administration with the Supreme Court. I agree that in many of these cases, I agree with Dan that the Trump administration might lose before the Supreme Court. They will win other cases. I just think there's so many of them that it's very hard to tell. The hardest cases are going to be those in which the administration's acting pursuant to statutes that are extraordinarily open-ended. Let's just take the Secretary of State's determination with respect to Mahmoud Khalil and his removal up in New York. The statute gives the Secretary of State on its face an extraordinarily broad discretion to remove someone, even a lawful permanent resident, because of particular determinations of his, staying in the United States will have profound foreign relations implications. If the courts get to the merits on that, where no one really thinks that is true, right? I mean, I don't think any reasonable person would think that his presence has a serious foreign policy implications. And if the courts defer to that sort of thing, which they might have been inclined to do in a different administration, that kind of rare Secretary of State determination, those will be the cases that are really going to test what the courts think about whether this administration is abusing the sort of authority that some of the Supreme Court's decisions have given to the unitary executive and to these broad statutory delegations. I think it's way too soon to tell how this is all going to fall out. But given that we only have 15 or 20 minutes left, I definitely want to hear from others in the audience and the students who have questions about these things.
Okay. And with that said, why don't we open it up to questions from the audience?
Or not.
We have a few submitted questions, and if you have questions in the audience, please raise your hand and we will come to you. But the first question we have here is, what is the likelihood that the court reconsiders Humphrey's executor in cases likely to reach the Supreme Court?
So far, because it's only in the DC Circuit, the government is arguing that these three cases that I mentioned, these three removals, are distinguishable from Humphrey's executor based on language in Chief Justice Roberts' opinion in Saylor Law that read Humphreys very narrowly. On the other hand, as I said, in that case, he suggested that the CFPB might be constitutional if it were a multi-member agency. So as the chief often does, he's left things quite open-ended so that he could go in a lot of different directions, depending on what he wants to do. I think there's a very good chance that as to what we might call regulatory agencies like the NLRB, there may be 5 votes for overruling Humphrey's executor. I don't want to predict that, but I think that's certainly many people think so. I think, and I hope the court will see some of these other agencies where it's absolutely clear why the injection of politics and political pressure and presidential pressure would just simply undermine the very function of that agency and or lead to possible disaster in terms of results, where they might carve out and make distinctions based on those functions of the agency, right? And start saying it won't be a broad holding like Humphrey's executor, or maybe not a broad holding that the president has absolute unitary control over everything that happens in the executive branch, but it will become a more functionalist sort of doctrine. Again, this is incredibly speculative, but I suspect when they see why he's doing what he's doing to control these agencies, which is to allow the government to act without regard to the law or to the usual procedural constraints that have applied for so many decades, that I hope that will give them some pause about the project that they started with cases like Saylor Law, but my predictive talents are usually proven to be quite questionable.
Did you have anything to add?
Well, I would just underscore the point about the Federal Reserve problem is significant because the Federal Reserve has the members of the board are protected against removal at will. It's not identical language to the Federal Trade Commission Act. It just says for cause, as opposed to the more specific grounds in the FTC Act. But nonetheless, I think there's this practical question of, are we worried about the consequences of exposing monetary policy to direct presidential control that might give the court some pause, even if they don't say so on paper? The other point that may, in the background, in kind of a realist mode, influence the thinking of some swing votes on the court is just whether this is the right moment to throw gasoline on the fire in terms of presidential control of the executive branch. And overruling Humphrey's executor would just send an incredibly strong signal of a very well-established precedent that's really structurally key to administrative law being swept away at a moment where the president is trying to maximally control authority over the executive branch. And so that might give them pause. I would not say I'm optimistic about that, though, because the theoretical currents among a majority of the court in favor of presidential power are so strong and so recently reiterated in Trump versus United States with regards to the president's immunity from criminal prosecution for matters in the core of his executive power, including his control over high-ranking executive officials, that I think it's going to be hard for the court to. I'm not sure the court will move in that direction, despite the risks.
Yeah, on that, two quick responses. One is the Fed is a problem. Judge Suknan on yesterday, in her opinion, mentioned that at the hearing, she asked the government lawyer, well, are there any exceptions to that? And they said the Fed. And she said, why? And they didn't have an answer yet. They hadn't figured out what their legal theory is yet on why the Fed is different. But obviously, it's the elephant in the middle of the room, and they're going to need to deal with it. And that leads to a more functionalist account. I will say, and I think I'm thinking that our panels this afternoon will probably touch more on the presidential immunity decision because because that sort of exacerbates the problems that Blake and I have been describing here, in that particularly the short part of the opinion that hasn't gotten as much attention as the criminal immunity part, the part where the Chief Justice suggests that not only does the president have Article 2 authority to listen to this, to direct Department of Justice officials to lie to state officials about what the evidence is of election fraud, that Article 2 not only gives him the right to do that, but that Congress cannot regulate that. Forget criminal law, cannot even pass a statute saying that's not okay. If the unitary executive includes not only the control over the executive branch, but the ability to control them in ways that disregards the law as such, which is, I can't believe the Chief Justice really thinks that to the fullest extent of his opinion, but there it is. That is truly problematic, and I think that this is right. I mean, Trump is taking what the chief has written in these two opinions and taking it literally and to the extreme and seeing how much he'll be able to get away with. I'm not sure they're worried if they lose a lot of these cases. I think if they have 50 cases up before the court and they lose 30 of them, they're fine with that. In other words, I don't know what the effect will be even if they lose, except that the judgments will at least be there.
Professor Farber, did you have anything you wanted to add?
So not much. I thought both comments were really perceptive. I guess in the realist mode, I think it depends on Roberts and Barrett, probably, what happens to Humphreys. So we'll see about that. Yeah, I don't know what they think about losing. I mean, in some sense, if they win any of the cases, they've gained a ton of power that presidents haven't had before. But on the other hand, one of the ways you keep power is by winning, and facing a series of setbacks could kind of undermine their image of invincibility. So yeah, guess we'll see.
Just one last point I'll add. I think one move that is available if they want to distinguish the Fed is to say that central banking is a core sovereign power, a matter of public right that is not subject to the same kinds of inherent executive control as the regulatory matters, and so it's more core to Congress's inherent authority, and so maybe there's an exception there. And some of the reason I think that's possible is that there are some early examples, like the Sinking Fund Commission, that from the early republic, that already suggest that the unitary executive theory doesn't apply to matters involving public monies. And so they could try to build out a theory of an exception with regards to that category of agencies that would cover the Fed.
I had used the QR code so I could benefit from anonymity, but I have to ask this question out loud now, although I think it's gotten better. Let me bookend my question. Professor Letterman, you started with the framework of the past, the present, and the future. I think we talked a lot about the past and the present. And Professor Farber had he used the word accrete when he was talking about powers that have sort of grown in the presidency, in the White House since President Reagan. My question is, in the post-Trump era, let's assume this model of the unitary executive comes into being to either a greater or lesser extent. What does that look like, especially knowing that occupants of the White House often take expansions of Article II power and use it to their own advantage within their own administrations? What does that look like, and what does that mean for us? And if we look at the sort of arc of history from the 17th century to now, it seems like the Article II power has expanded at maybe the expense or diminishing of the primacy of Congress. What does that look like, and why does it seem that the public is so in favor of that generally? Sorry, that's a bunch of stuff, so take what you want from that.
I really don't know. I mean, I was weaned. I've been in the Justice Department 3 times with several people here in the room and others, and I was taught, and I'm a big believer in proceduralism, and you might call it Obama, Biden, Merrick Garland proceduralism. And the Republican Party has, caricatured and characterized everything that went on in the Garland Justice Department as having been politically tainted, which is, if you know the players, is the most absurd thing one can imagine. And so I don't think that my generation of lawyers and officials are going to be the ones doing this the next time around. I think it will be people that feel as though they played by the rules and this is what they got. And if the Supreme Court is going to empower a president to be able to act without so many guardrails, both internally and externally, how can that be exercised in a responsible way? I mean, these are people who have grown up thinking that procedural regularity and debate and legal norms and legal checks are very important and lead to better policies and better governance and better results for the United States. But when they know that the courts aren't going to stop them, and when they know that there's no political salience in that, or little, as you suggest, not much political, you're not going to run on, defending proceduralism any longer. I really don't know what it looks like. Over the course of the day, I hope some of our fellow panelists will speculate on that. I think there's so many variables that it just remains to be seen, and it depends largely who the presidents who are elected are and the types of people that they hire around them.
Do you want to wrap this up?
We'll do one more. One more quick one.
Do we have any from our fellow panelists? No.
Okay. This question asks, given that Justice Barrett and Chief Justice Roberts are probably going to be swing votes in those upcoming administrative law decisions, where does their jurisprudence on the subject leave them with regards to their stance on the unitary executive theory and the power of administrative agencies in general?
Well, Chief Justice Roberts is one of the main architects on the current court of the unitary executive theory in action. So as far as he goes, I think his position is broadly skepticism of regulatory independence, as well as just the regulatory authority of administrative agencies more broadly. However, and this is where the ambiguity comes in, and leaving your options open. Saylor law did not, and pointedly did not, overrule Humphrey's executor. It left it in place and kind of relied on it as one of the kind of crutches for between Humphrey's executor saying multi-member commissions are okay, and interpreting Morrison versus Olson as saying it's okay to have a restriction on an inferior officer, at least in some contexts. So his jurisprudence, it does leave open, as Professor Letterman suggested, the possibility of preserving administrative independence at some levels and in some contexts. But the philosophy or the ideology behind those opinions is one of ever increasing presidential control. And when I see that, when I see that philosophy at work in the immunity decision, it makes me not have much confidence. I don't have a read on Justice Barrett on these questions, honestly. I don't know if the other
except that in the immunity case, she wrote separately and really was trying to temper things. Yeah. I would say, and I'm curious what Dan thinks about this as well. I think that Justice Barrett's separate concurrence in the major question case, in the Missouri separate major question case, and others, and the Chief's writings on this, suggest that they are very dubious of the administrative state as a whole, putting aside the president for a moment, taking on questions that her assumption of the way the world works in Congress is that Congress hasn't meant to really confer this level of discretion and this degree of openness to the agencies, that they want to hold on to those questions for themselves, and that's the way our schoolhouse rock government is supposed to work, right? That Congress should be deliberating and debating among these things. I think they believe in that genuinely. I don't think that's a pretext. They also look at what's going on, and we don't see the Congress acting that way at all. And now they see a president who is acting, with respect to, in much more majorly ways, with respect to much more major questions than happened in the predecessor administrations. And I think that will give them some discomfort in a lot of contexts. I don't know whether that will carry over to immigration and foreign affairs and the like, but I'd have to think that it's not the way they appear to understand the system is supposed to work. But they're also pretty tough-headed realists, and I don't think that I'm not sure they think that they can sort of reform Congress and make it into the deliberative legislative body dealing seriously with these problems that they imagine it ought to be, or that it's supposed to be. So I think they're going to feel a bit of internal tension about how they approach these things. And again, I think it may be very, very case specific. But
Professor,
Dan, I'm curious, can we give Dan just a
yeah,
second?
Professor Farber wanted to give you the last word.
Yeah, I agree with that. I think in some ways the Trump administration has made things difficult for them by sort of rubbing their nose in the consequences of granting the president such enormous personal control of the government. You know, sort of the parade of horribles seems to be at the doorstep. Um, I remember reading about Humphrey's executor that Brandeis, the case was in the 30s, and Brandeis remarked that, you know, if they gave the president the power to remove everybody, including the heads of agencies like the FTC, it would be opening the door to Mussolini like government. And I think that, you know, that specter might start to worry at least some of the justices, but we'll see.
Okay, well, let's thank our panelists for a very interesting discussion.
Before entering academia, Professor Frost clerked on the U.S. Court of Appeals for the D.C. Circuit and spent 5 years litigating at all levels as an attorney at Public Citizen. She has also worked for the Senate Judiciary Committee, served as an acting director of the Immigrant Justice Clinic at American University, and spent a year as a Fulbright scholar studying transparency reform in the EU. So please welcome Professor Frost. Our second esteemed panelist, Vikram Amar, returned to UC Davis as Distinguished Professor of Law in 2023, after having served as the Dean at University of Illinois Urbana-Champaign College of Law since 2015. Professor Amar has also taught law at Berkeley School of Law, UC Law San Francisco, and UCLA School of Law. Professor Amar is one of the most frequently cited authorities in constitutional law, federal courts, and civil procedure. He has produced several books and more than 60 articles in leading law reviews. He's an elected member of the American Law Institute and has served as a consultant for a wide range of entities, including the National Association of Attorneys General, the U.S. Department of Justice, the California Attorney General's Office, and the ACLU of Southern California. Professor Amar earned his bachelor's degree from UC Berkeley and his JD from Yale Law School, where he was articles editor for the Yale Law Journal. He then clerked for Judge William A. Norris of the U.S. Court of Appeals for the Ninth Circuit and Justice Harry A. Blackmun of the U.S. Supreme Court before joining Gibson, Dunn, and Crutcher, where he handled a variety of civil and white-collar criminal matters. Follow Professor Amar's biweekly column at justia.com and read his archive posts from his findlaw.com column. Please join me in welcoming Professor Amar. All right, so we'll begin with Professor Frost.
Great. Thank you so much for inviting me. Special thanks to Matthew Agayan, Jacqueline Kessel, the entire Law Review, all the people that made this conference possible. Having attended many conferences and run a few myself, I can see an excellently run conference. I know an excellently run conference when I see one, and this is one of those. So thank you. Also wanted to say that at the outset that I really encourage questions and participation. I'm going to be speaking about immigration, and I'm assuming most people won't have taken the immigration class or necessarily be specialists in that topic. So I both welcome questions about some of the things I may cover quickly and hope that we can have a discussion about those. So just to get started, I'm going to start my talk by going over President Trump's immigration initiatives. You'll see I have two columns. I hope you can see the slide. Yes. What the executive can do and what the executive cannot do. And I'll say at the outset that I am simplifying a little bit here, more than a little bit, in terms of both describing the President Trump's initiatives as well as describing whether they're legally permissible or not. So I'm more than happy, as I said, to take questions and go into more detail. After briefly outlining some of these initiatives, I'm then going to dig a little deeper into the interaction between President Trump and his initiative to try to deport a significant number of undocumented immigrants and the pushback from states, so-called sanctuary jurisdictions. So I'll spend a little time talking about that. And then at the end of my talk, I'm going to mention an area in which President Trump has not issued an executive order or attempted to exercise sweeping executive authority. And that's in the area of prosecuting or pursuing Americans who hire undocumented immigrants. So I'll talk about that at the end. In the list of what the executive can do, and this is because both statutes allow for it and or there's precedent. So suspend, oversee refugee programs. That is pretty much within the executive's discretion in terms of setting numbers and suspending that program. Trump has done that, and legally he is broadly permitted to do that. To ban or bar non-citizens' entry into the United States, at least in the short term. Again, President Trump any president would have great authority to do so. That question was tested in the first Trump administration when it came to the travel ban. It came up to the US Supreme Court. There was a question about his authority under the Immigration and Nationality Act, Section 212F. The Supreme Court, while not leaving it completely unbounded, did say the president has great discretion to suspend entry of non-citizens. And so again, the president has authority to do that and has done that. And I have heard sort of rumors on the ground that additional travel bans are coming, so stay tuned. Reinstate the Remain in Mexico program. This, you may remember from the first Trump administration, was the initiative that said anyone coming to the US southern border seeking asylum could not enter the United States, with very few exceptions, but instead would have to wait for their asylum interview outside of the United States in Mexico. I thought this was one of the more effective things the Trump administration did to try to slow down immigration and certainly slow down the arrivals at the southern border and slow down asylum seekers, in part because non-citizens outside the United States have very limited constitutional rights, unlike non-citizens in the United States. And also because, of course, it made it harder for them to access lawyers and assistance. And he has said he would reinstate that. Currently, there's many fewer people coming to the southern border, but Mexico is allowing it, and he has done that. Use the military. Again, there's some limits in using military and immigration enforcement domestically, but it's permitted at least in some manner, way, shape, and form. And so he can do that. And this is the key, use willing local police forces and state police forces to assist in immigration enforcement. This is essential for him to achieve his agenda, and this is something that he has some authority to do with those states and localities that are willing, and we'll get into what happens with those who are not willing in a minute. End various forms of temporary status, like temporary protected status. That's a status given to people from countries that either have a natural disaster or civil unrest. Haiti would be one example, Venezuela another. He can end that, and he's done that for some countries. End these blanket parole programs that the Biden administration put into place, giving parole to people from Cuba, Haiti, Nicaragua, and Venezuela. He can end those, and he's done that. And end DACA. Now, again, I'm simplifying here. He tried his first term and failed because he didn't do it legally correctly, in violation of the Administrative and Procedures Act. But he has a great deal of authority to end that program, and I think likely would do so and likely would be upheld if he did so in the procedurally correct way. And he can deport undocumented immigrants. But there's a lot of logistical and practical problems to that, which is why we'll get into that issue in 1 minute. So what can he not do, at least for now? As you'll see in my little parenthetical, I give myself that caveat. So he can't end birthright citizenship because it's in the Constitution as well as in a federal statute. I'm happy to talk about that more in the Q&A, but I'll move on from that right now. He can't deport without a judicial hearing, that is before an immigration judge, immigrants who have lived in the United States for more than 2 years, whether they're authorized or not. I will say I've read today, this is like the kind of thing that changes day by day, that the president's hoping to use the Alien Enemies Act to get around that restriction. That's important because that really slows down one of the things I said he can do, which is deport undocumented immigrants. Because if those undocumented immigrants get the right to be before a judge and have a hearing, in our current system, that can take a long time. They have due process rights, rights to present evidence. All of this will slow down that goal of removing undocumented immigrants and will also be quite costly and expensive. So that's a hurdle, a barrier, which of course he's trying to overcome in various ways, including through potential use of that Alien Enemies Act, which would be a way in which he would try to avoid the requirement to hold hearings for those individuals that would surely be litigated. He can't detain people indefinitely. There was a Supreme Court case on this, now over 20 years old, Zedvitas, where the government said, well, if they found somebody who's an undocumented immigrant, that person has no right to remain, but there's no country that will take them, the government can just leave them in jail forever. And the Supreme Court in a case called Zedvitas said, no, you can't. So if the president cannot find countries to take the people that are undocumented that he wants to deport, then at least at this point in time, he cannot hold them indefinitely and would have to release them back into the United States. Deport legal immigrants for constitutionally protected activity. So that is another question that's soon to be tested with people like Mahmoud Khalid, who is the Columbia University student on a green card, who is the administration is attempting to remove. Professor Liederman spoke about this briefly in the first panel, and again, we can discuss, but at least at this moment, there would be First Amendment protections for a green card holder in the United States, such that they could not be removed for purely First Amendment activity, with plenty of caveats around that, as we'll see what the court does. And finally, which we'll spend a little more time on today, I know myself as well as Professor Amar, the president cannot require or mandate that unwilling states assist, and I put that word in italics, federal immigration enforcement. So that is a super quick, like 6-7 minute overview. As I said, happy to and hope to get questions on some of that. But I want to dig in to some of the practical problems, not just legal problems, but practical problems, which then dovetail with the legal problems of removing the undocumented immigrants, something the president can legally do, as I said, but the practical problems are enormous. And that's where he's going to need the lever or the force multiplier of the military and the states. There's 12 million undocumented immigrants approximately in the United States. The cost of removing them all, $315 billion. Even if you're saying, all right, we won't go that far, but we'll just remove way more than we've removed before, 1 million a year, let's say, that's $88 billion. The current budget, $9 billion. The bed space in detention centers, 46,000 people and currently at capacity. So this is going to be very difficult and expensive for the administration to do. So we enter into this point about, okay, let's see if we can get the states helping us engage in immigration enforcement. That was in part this executive order protecting the people, the American people against invasion. And the president in that executive order said, we're going to try to get these so-called sanctuary jurisdictions to start assisting. So first thing I'll say is nobody likes the term sanctuary city or jurisdiction, including people that are labeled that, and the people, obviously people don't like it who think that they should not exist. It's a misnomer. Nobody would ever be able to say to any undocumented immigrant, well, you're safe here. This is a sanctuary. There was a debate on my old law school, should we call our campus a sanctuary campus? And I said, absolutely not, for so many reasons. And one being, we cannot provide a sanctuary in the sense of if immigration officials come to our campus with a warrant signed by a judge, not an administrative warrant, but one signed by a judge, the law requires we let that person on the campus and they can arrest, detain, deport that person. So it's just a misnomer. I'll also say that when we call various cities or localities or states sanctuary cities or jurisdictions, they're not all the same. They all have many different policies in place and they operate differently. They have different exceptions. So it's really hard to give a blanket term for all of these jurisdictions. That said, of course, there are jurisdictions in the United States that have decided through legislation enacted by the state that they are not going to assist in immigration enforcement. This map shows you, it's sort of an interesting map because it shows you two types of states. Of course, there's the states which are in the teal or green, and those are the states that are called sanctuary states or sanctuary jurisdictions. They're pro-immigrant and they're enacting laws to try to hinder or at least not help immigration enforcement. And then the purple states are like, let's do more. Let's go full on and try to assist and even go further than the federal government in immigration enforcement. So when we talk about sanctuary cities or jurisdictions, what are they doing? A variety of things, not all the same things. One is they're saying we're not going to comply with immigration detainers issued by ICE, which means we're not going to hold people in jail for longer than we would if we picked them up and found we didn't have any cause to keep them. We're not going to hold them longer just because ICE tells us to. And part of the reason that these states don't do this is some of them were sued if they did do this and had to pay out large monetary awards to people who were held beyond the time that they were permitted to in violation of the Fourth Amendment. Other jurisdictions just say this is not how we want to interact with our community. Refusing ICE access to the local jails, which where they may have undocumented immigrants, and refusing to allow them also to use local detention facilities to house undocumented immigrants who are in deportation proceedings. Refusing to gather immigration data, and refusing to participate in joint operations. These are all things that sanctuary cities have said that they will not be doing, or sanctuary jurisdictions. This has been, of course, the subject of a lot of political heat. We see here 4 mayors from sanctuary, so-called sanctuary states and cities testifying before Congress on March 5th. We've got Boston, Denver, New York City, and Chicago all defending their policies. And we also have a lawsuit that has been brought against the state of Illinois about its policies. It has enacted 2 laws that are relevant here. The Trust Act, enacted in 2017 under a Republican governor, and then a Way Forward Act, another law. And together, those acts do much of what I just described in my previous slide, where they will not honor ICE detainers, will not gather immigration data, will not engage in joint enforcement activities, and the state of Illinois will not house undocumented immigrants in Illinois. And currently, the Trump administration is suing, and that I will leave to my fellow panelists to discuss in more detail. But the state's argument, in short, is we cannot bar you from coming into our state and enforcing federal immigration law, but nor can you force us, state actors and local officials, to do your federal bidding, in part because we have a relationship with our constituents, people in our state, such that we don't want to undermine those relationships. And we want the lines of accountability to be clear. It is not the local police force that is arresting and enforcing immigration law. It's the federal immigration authorities that are doing so. And that is, of course, something the Supreme Court has discussed in its previous precedent on anti-commandeering, not where the federal government is not enabled to use state and local officials to accomplish its federal goals. And again, I'll leave that to my co-panelist to discuss in more detail. All right, so the last couple points I want to make. One is that I'm interested in the fact that the Trump administration has so far focused much of its enforcement efforts, not all, but much of its enforcement efforts on blue states. I find that curious. Like, if you were elected by people who are furious about immigration, and by the way, I think there's a lot that's gone wrong with our immigration system, and I was no great defender of Biden policies on this. But if you were elected because people in these red states said, we're overwhelmed, we need help, these undocumented immigrants are flooding into our state, help us. I find it curious that so much enforcement effort is in the blue states, right? So think about that. And the second thing that I find interesting is there's no executive order pursuing US citizens who hire undocumented immigrants. And these undocumented immigrants are all working. So they're about 5% of the labor force in the United States are undocumented immigrants. It's more in some states. In Texas, it's 8%. Texas has not used various mechanisms and not adopted them that it could have. It uses E-Verify only in limited circumstances. E-Verify is a way in which you can check if you're an employer whether the person you've hired is permitted to work. Texas doesn't mandate the use of E-Verify as broadly as it could. 8% of its workforce are undocumented immigrants, and a far larger percentage are in certain fields like construction, like the service industries, such as farming, et cetera, as you see on this slide. And that violates the law. When a US citizen hires an undocumented immigrant, if they do it knowingly, it's a crime. If they do it without filling out the I-9 paperwork that we've all in this room filled out to work, or done so knowing that the document provided is false or incorrect in terms of that form, that's also a violation of law for which employers can be fined. And yet there's no executive order that is seeking to really unleash the power of the executive on these US citizens. I'll note the first Trump administration, in 2018, there were 65,000 people prosecuted, undocumented immigrants, for illegally entering the United States. There were 11 US employers prosecuted for hiring undocumented immigrants. All right. I'll stop here.
Thank you, Mary, and thank you, Amanda, for laying the table so beautifully. I want to thank the students for inviting all of us, and Professors Pashaw and Johnson for their help of the law review. It's always a pleasure to be here. As Dan Farber said earlier this morning, there are some ways in which what we're seeing now is similar to what we saw in 2017. But as Marty pointed out earlier, this is like, 2017 Trump Roman 1 kind of on steroids, both in terms of quality and quantity. It's just it's so much more aggressive in terms of the number of things that the administration is doing and the aggressiveness of what the administration is doing. So in a forum like this, we can't really resolve much, but I think we can, in the finest tradition of law schools, at least spot and analyze some issues that are going to obviously be playing out in the coming months and years. As was true in 2017, and as Amanda kind of adverted to, the administration's strategy here proceeds along several parallel tracks. There are executive orders, there are threats, there's kind of interim statements by the administration to kind of cow individuals and states and municipalities into compliance. And then there's formal litigation, like the case that Mary mentioned, this Amanda mentioned, United States versus the state of Illinois, and I'll come back to that in a few moments. The lawsuit that I'm going to talk about, like much of what has come out of the Trump administration so far, whether you agree with its policy, whether you agree with its unfolding, evolving legal rationale, is really poor work product. It's very poor quality. The complaint has typos, missed words. I mean, this is not what you would expect in the DOJ, as kind of Marty talked about. A lot of people are making this stuff up as they go, even if they have some plausible legal bases. So it's actually quite hard from this litigation to see exactly what it is the administration thinks that Illinois or Cook County or Chicago is doing that is violative of federal law. It's a bit of a rant as much as it is a carefully crafted complaint. For example, it'll just list a bunch of things that Illinois has done, and then it'll later double back and talk about how the challenged provisions are illegal, but it never identifies exactly what those challenged provisions are. But the major theme of the lawsuit, and what I want to talk about, is one Amanda mentioned. The federal government wants more cooperation from the states and the localities. They want more involvement. They want more coordination. They want more kind of help. And there are two different kinds of remedies that the administration is pursuing, again, on parallel tracks, to try to get that additional assistance. One are straightforward judicial commands to cities and states to stop doing what they're doing or to do what they don't want to do. So judicial directives backed up by contempt sanctions against state and local officers is a very traditional remedy. And then you've got a parallel track of withholding federal dollars, sometimes in narrow areas and sometimes across the board. You don't get any money unless you do what we want you to do in this little window. So let me talk about the funding doctrine first, and then I'll come back to whether the federal government can get courts to order states and localities to play ball. With regard to denial of funding, there are a number of issues that will play out in the courts that you have to keep your eye on. First is whether the demands that the administration is making before money will be paid out, whether those demands were codified in federal statute, whether Congress actually wanted states to have to live up to those demands. So there's a separation of powers underlay to this. Are these conditions, are these requirements that the administration is imposing, are they made up by the administration, or are they within the scope of delegation given by the statutes consistent with the major questions doctrine and Loper-Bright and the like? So there's that big separation of powers issue, as well as the federalism issues we'll talk about in a few moments. Second, even if these conditions are consistent with what Congress has provided? Were they unambiguously articulated in an early enough time to the recipients to satisfy due process and contract law principles? So in both Sebelius and South Dakota versus Dole, the Supreme Court has said, especially where state and local entities are the recipients of federal funds, the conditions have to come from Congress and they have to be articulated unambiguously so there's not a bait and switch, so that the states and localities know what they're getting into when they decide to accept the money in the first place. Then under Sebelius and Dole, the conditions have to be related to the reason the federal money is being spent in the first place. So the relatedness prong is actually not something the Supreme Court has ever used to strike down a federal spending program. But, and indeed, in South Dakota versus Dole, then Justice Rehnquist was kind of coy. He didn't really say this is a requirement. He said prior cases have suggested that this is something that we look at, is the relationship between the string and the provision of money in the first place. And then, of course, we have Sebelius's kind of additional requirement that the withholding of funds, even if the notice is fine and even if there's relatedness, in the Medicaid context, and Sebelius, John Roberts for the majority said, well, you can't withhold funding that states or cities have relied on in such a prominent way that it blows a hole in their budget. This kind of, you can't, too much, too big to pull back, if you will. I don't know whether that's going to be, that rationale obviously was subject to a lot of criticism. I don't know whether it's going to survive the cases going forward, or if that was just part of the deal by which Sebelius got done in the Obamacare setting. Okay, so that's the funding side. Now, what about the more direct assault? The feds just say, you have to play ball with us. You have to assist us. You have to do what we say. Well, how much authority they have to do that depends on the commitment the court has to Prince versus United States and exactly what Prince means, the scope of Prince. So you remember from con law, the two big anti-commandeering cases, New York versus United States, involving a demand that the state of New York pass legislation regulating radioactive waste. The Supreme Court said you can't just tell a state legislature it has to pass laws pursuant to a federal agenda. That's not federalism. And then 5 years later, in 1997, the Supreme Court followed up New York with Prince, holding that the federal government could not require law enforcement officers to do background checks under the Brady Act until the federal bureaucracy ramped up. That states have the power to decline to provide executive enforcement assistance, just as they have the discretion not to pass laws pursuant to a federal vision. Now, for a long time, the court didn't really revisit either of these cases. About 7 years ago, in NC2A versus Murphy, a case involving sports betting, the Supreme Court doubled down on New York versus United States and said that Congress couldn't force New Jersey to pass laws regulating sports betting. Alito's opinion made a hash of the doctrine. One of the things that's a problem is the Supreme Court and lower courts don't really pay close attention to the uber important distinction between impermissible commandeering on the one hand and permissible conditional preemption on the other hand. Congress can tell states, we can't force you to do anything, but if you don't do what we want, we will preempt you, and here's how you can avoid that preemption by complying with certain conditions. That's actually what the statute in Murphy best read did, although the court didn't quite appreciate that. It's not entirely clear how much sense Prince and New York make. Certainly the rationale that was advanced, and Amanda mentioned this, the keeping lines of accountability straight. I don't know too many people who think that is a really good rationale. Why? Because in both New York and Prince, the court pointed out, Congress can bribe states to get what it wants done through the spending clause, and it can threaten to preempt. even though it's not always attentive since those cases to what statutes really fall in that category. So if you can threaten to preempt and force them to do your bidding because they don't want to be preempted in a way that would be even less popular with the local electorate, or you can bribe them to cooperate, how are those devices facilitative of transparency and accountability? The court gave no real explanation for why commands are different from those two with respect to accountability. Now, they may be different. Commands may be different in the sense that we want states to be able to articulate a vision of regulation that differs from the federal model. We want states to be a counterpoint. They can articulate a different set of ways of approaching different problems that we encounter in society. And if the federal government could consume all the time of those state bodies who are charged with laying out a vision of what the state thinks is a good way to govern, then the state could never have the ability to articulate that counter vision. But that rationale really puts pressure on the distinction between state institutions like legislatures that do define the state vision of the good life and the good government from executive officials who really don't play that much of a role in defining what a state's approach is, but they're really just executors. They're just administrators. They just take the vision that comes from the policymakers and runs with it. So, governors may be more like legislatures than cops, but in Prince, we're talking about cops, local sheriffs. How much do they have to do with defining what the law in Michigan really is? Relatedly, we all know that courts are not entitled to protection from the anti-commandeering doctrine. Federal law under Tester versus Catt and elsewhere can impose obligations on state courts to process federal law. And so if you ask, are state courts at one end of the spectrum and the legislature in New York versus the United States is at the other end of the spectrum, where do executive officials fall? Well, in some ways, they're closer to state courts than they are to the legislature because they too enforce laws made by other entities rather than generating their own law. So it's not clear how durable the anti-commandeering doctrine is going to be, especially as regard to Prince and executive officials, because Murphy involved New York versus United States much more than Prince. Now, 2 years ago, in 2023, the Supreme Court did decide Halen versus Brackeen, the ICWA case, the Indian Children Welfare Act, that was involved some challenges to commandeering, or based on commandeering. But the court kind of dodged the issues there, saying that the ICWA statute didn't impose requirements on state executive officials that were not also imposed on private people. And so it's not really commandeering if you're imposing a general obligation that applies to public and private folks. So they certainly didn't shy away from Prince, but that case didn't really involve a direct a resurrection of a Prince kind of argument. Let's assume that Prince does remain good law. What does it mean? Well, now let's come back to the kinds of cooperation that are at issue in the Illinois case. And then I'll just have one or two other points to make. So as Amanda pointed out, one of the things the federal government wants states to do is to report information they have on the status of individuals and the timing of their release to the extent that they are in a state custody. So tell us who you know who's here unlawfully and when you're going to let them go. Second, help us collect information on people who might be here unlawfully. Help us do the investigative work. Give us the benefit of your intelligence networks. Third, provide us access to the people who are in your custody. Fourth, detain them long enough so we can come get them. Keep them longer than you otherwise would, as Amanda said. So those are the four big themes that run through the complaint. Unifying those themes is this kind of somewhat bizarre I shouldn't call it bizarre, somewhat overblown criticism that Illinois is discriminating against the federal government by not helping it. But the very essence of New York versus United States and Prince is you can discriminate against the federal government, at least up to the point that those cases authorize non-cooperation. You cannot interfere with the federal government. You cannot impede. And that, of course, is where the tough line is between non-participation and interference. But within the realm of non-participation, of course, you're discriminating against the federal government because you disagree with their policies. All right. So now let's break down each of those and just say a few words about it. With regard to the reporting of information already in the hands of state and local officials, Prince kind of cuts both ways. On the one hand, the majority opinion seems to bracket that issue, and O'Connor's concurrence seems to say, I'm glad they bracketed that issue. But then in another part of the majority opinion that O'Connor joins, Scalia says, well, the reason why this is not like requiring private people to turn over what they have is this information is owned by the state. The state collected it and the state owned it. So it's not analogous to private information that the government can require private persons to turn over. So Prince speaks in both directions on this. And it's not clear to me where that now ICWA, some of ICWA's provisions in 2023 involved information reporting. And interestingly, there, the court did not say qualitatively, reporting of information falls outside of Prince and can be mandated by the federal government. It said the courts can be required in the states to report information. It was a very narrow reading of the language in Prince, which talked about information more generally and as applied to executive officials, not courts. We already knew courts could be pushed around. That's Testa versus Cat. So ICWA wasn't, Halen versus Brackeen wasn't really helpful or clear on what it adds in this respect. So that's collecting information, reporting information. What about collecting the information, doing the investigation? Well, that's Prince. And if there's anything left of Prince, you can't force the cops to go out there in the field and gather the information. Third, the access to people in the prisons. I have a hard time thinking the federal government won't win on that. Because that, then you really do get close to a sanctuary. If those people weren't housed in the local jail, the federal government might be able to get to them more easily. They might be out there on the street. So the state can't say, you can't come into our jails and get these folks when otherwise you might have other ways of getting them. That pushes really the sanctuary concept in a problematic way. And more generally, let's be clear, to the extent that Prince does or should or will survive, it has to be limited to situations where the federal government is asking states or forcing states to exercise executive authority, not where the state is controlling executive resources like land. There was a Ninth Circuit case last fall in which the King County, where Seattle is, wanted to close off its airport to ICE transport planes, to ICE charters. And the Ninth Circuit rightly said, the states can't, even if they're not opening up these facilities to the public more generally, you can't say ICE vehicles can't drive on state roads. I mean, that really would violate McCulloch. It can't be about resources. It has to be about use of state governmental sovereign executive authority. So I think on the access to the people in the prisons, I think they're in. Now, the hardest case for the federal government will be forcing longer detention than would otherwise be justified under state law. Then you really are talking about forcing a state to exercise core executive sovereign authority in ways that it doesn't want to do and that it otherwise would not do. So last thing I'll say, and then throw it back to Amanda. Let's double back to the funding question. I think there's an interesting under-discussed issue here. That is, let's imagine that Prince goes away, or Prince is limited, or Prince it doesn't apply to some of what the federal government is demanding that state and local governments do. So you could go get a court to order the local officials to open up the prisons, for example, or to provide information that's already in their possession, rather than go out and collect it. So you can go that route. Can you also simply cut off funding as a separate remedy instead of the contempt power. In other words, can you say, if you don't comply with valid orders that aren't protected by the anti-commandeering doctrine and Prince, then you lose all federal funds? Why is that an important question? Because states are a lot more worried about losing money than they are about having their officers subject to contempt. Now, you still might say, well, you have to at least have told them ex ante that this could be a consequence. There has to be notice. But let's say every funding condition going forward has a generic provision that the recipient of federal funds has to comply with all lawful commands by the federal government to cooperate with federal law. Okay? So you can put just a cross-cutting provision in there. And then if a state violates that, are they at risk of losing all funding, no matter how unrelated that funding might be to the particular violation, the particular failure to help? This is a court that's supposed to believe in federalism, even as it also believes in a strong executive. So we'll see where that goes.
All right, thank you so much. I think before we move to the Q&A, I wanted to give each of you an opportunity to engage with the others' remarks.
Yeah, so I certainly agree with and learn from your description of the major cases in this area and how the Trump administration could use various techniques or tools or methods to try to either coerce or require states to participate in immigration enforcement. The one piece I'll add or maybe just respond to on the jails. So what localities were objecting to, the jurisdictions that have said you can't use our detention facilities, I take the point, like you can't bar certainly somebody with a warrant from coming in and accessing a person that this federal government officer from coming in and accessing a person that's held by the state. But that wasn't the major complaint by states and jurisdictions was we are not going to use our detention facilities to hold undocumented immigrants, which is something states had been doing. And maybe not everyone's aware of this, but when undocumented immigrants who some of them have committed crimes, some of them have committed crimes that are immigration crimes only. But a lot of them are just, they've overstayed a visa. That's more than half of our undocumented immigrants. That's not a crime. And they can be deported, of course. But where are they housed while they're waiting to be deported? It's often in a jail or jail-like setting. I go with my students and do some work with this population sometimes, and you can't really see a difference between them. And in fact, some states and localities have let immigration officials use the state jails and prisons to house immigrants. And so one of the things these states like Illinois are saying is, we're not going to do that. You build your own detention facilities. And that's a problem when you saw my slide with 46,000 beds ICE has in its detention facilities, but it wants to remove 12 million people. So that's one problem. And the other thing that they won't do, that the Trump administration wants them to do, is tell them when the detained person, let's say the person who committed a state violation of law has been imprisoned, is a criminal, has been imprisoned under state law. They're an undocumented immigrant, or maybe now they've lost their status because of that crime. And they're going to be released, let's say 2 years after they were imprisoned. The Trump administration wants the state of Illinois to say exactly when that person's going to be released so they can get them as they're released and deport them. And that's what states are refusing to do. So it's really more like an information sharing than it is accessing our jails, right? So I'll just make those two distinctions. I'll say I entirely agree this is going to come down probably to more coercive methods like funding. That would certainly, I think, force states to cooperate in ways that they don't want to. And the last piece I'll just say is, without the ability either to get far more funding from Congress, like in the billions, or the ability to use these state officials, the Trump administration will find it very hard to succeed in its goal to deport. I'll remind you, he was president before. He said this before, and the undocumented population did not change. 3/4 of the arrests and deportations under all the administrations are from people that are already detained. It is very, very difficult and expensive to find undocumented immigrants in the United States, which is why I think if you truly cared to end undocumented immigration in the United States, you would go to the people you can find, the US citizens who are employing them, and discourage them from doing that. So I'll just leave it there.
Great, thanks. So let me take the 2 points you made about the prisons in reverse order. So the turning over the information as to the date of release is, as you said and as I said, it's a question of whether Prince covers information reporting, information that's already gathered. This is not something they have to go out and work to get. It's just in their heads, it's in their records, it's in their minds. Do they have to turn that over? I think there's a good chance that information will be kind of lopped off of Prince, even if Prince survives, and they will have to do that. Now, on the housing of the folks, here's where I think we got to pay real strict attention to details. If we're talking about just using the space, we're going to provide the manpower, the person power. The federal government's going to provide the people to operate it. But we just need a roof to hold these. That's commandeering in the old-fashioned sense. That's like, I need your car, I'm taking it. The federal government can exercise the power of eminent domain over state and local governments. So I don't know why they couldn't do the same in this context. That to me is different from, and your guards shall watch these folks for us. To the extent that there is anything to Prince, if it makes any sense, that's core executive power. Again, maybe Prince doesn't make sense because they're not making policy the way legislatures are. But if Prince survives, it's hard to see it surviving without states being able to withhold their person power to actually coerce individuals. But if it's just a matter of, this is an empty facility, let us use it to house them, that to me is like the roadway. Can you tell ICE it cannot drive its trucks on a state highway? I just don't see that. So that's that. Now, on it seems you're so right to me on going after employers. And the only thing I'll say about that is it relates to your earlier observation about going after blue states. I mean, there's a performative quality to all of this. And yeah, the red state folks are the ones who are complaining about having been burdened by illegal immigration. But they'd rather see you go after the blue states than go after themselves, in part because then they're not going to have the labor force that they thought they had. And, home health care and construction industry is going to be affected and the like, and the tax base. So that doesn't surprise me that there's a mismatch between the policy rhetoric and the steps in the first several weeks.
All right, great. Thank you both so much. The last point's about it being performative and sort of just for rhetorical effect leads to the discussion on birthright citizenship, which I hope we could talk about. Both of our panelists have been active just in the last few days on podcasts, last month, congressional testimony, Justia article. So I wondered if you could flesh out for the audience a little bit more about first what the EO purports to do, what some of the alternative interpretations that a few scholars have promoted would look like. I take it from your writing on this that you find them to be implausible. So if you could talk about why, and then sort of what the end game is of the administration. If it is just sort of on its face, it appears that it won't withstand any sort of challenge, is the goal to begin a discussion to try to get a constitutional amendment? Is it just performative? Sort of, what do you think the aims are?
Yes, and I'll describe the EO and would love to hear thoughts as well about sort of the arguments against the arguments for the constitutional reinterpretation. Before I do that, I'll just say I also, I do think, as I said in some of my initial comments, that immigration is rightly a topic of public concern on which the American public is deeply divided, and it raises lots of important questions, and there's no one right answer. I do think that this administration's been hypocritical in its enforcement approach, but that doesn't mean there aren't people with genuine views that want to restrict immigration. And I just want to say I welcome those conversations too, just in case that isn't clear. In terms of the executive order purporting to end birthright citizenship, so it's framed in, I find this really fascinating, the way it's written. So Section 1 says, we've gotten it wrong in this country for like a century plus in how we've interpreted birthright, the citizenship clause of the 14th Amendment, which was added to the Constitution in 1868. It was one of the Reconstruction amendments intended to overrule Dred Scott and very explicitly in the debates also to make citizens the children of all immigrants, including Chinese immigrants arriving at that time, who were a population that was becoming vilified. There was a lot of anti-Chinese animus. So there was a concrete discussion at the moment in which it was ratified. We intended to overrule Dred Scott, give citizenship to all the former slaves and the children of immigrants. That was added in 1868, and starting with a Supreme Court decision in 1898, the interpretation had been that it, with some debate here and there at the margins, but generally speaking, the view was birthright citizenship applies to everyone born in the United States, regardless of the status of their parents, with exceptions only for diplomats, children of diplomats, and children born into Native American tribes. But the Trump executive order says in Section 1 that that interpretation has been wrong, and in fact, the citizenship clause only gives automatic citizenship at birth to children who have at least one parent who's a citizen or at least one parent who's a green card holder. And the children of two undocumented immigrants, or even two lawfully present but temporary immigrants, which can include not just tourists, but people on H-1B visas, work visas, student visas, people who might be in the US for many, many years and on their way to getting green cards, those children would not be citizens. And that's just what it says. Section 1 just interprets the 14th Amendment citizenship clause. Section 2, and it doesn't say retroactive or prospective, it just says we've gotten it wrong all this time. Those people aren't citizens. Section 2 says 30 days from the date of this order, we will instruct federal agencies neither to issue nor receive citizenship documentation that doesn't demonstrate, I assume, that somebody's parent is at least a green card holder or citizen. So that's really interesting because it's saying a huge number of people in the US today are not citizens, but we're only going to start treating people as not being citizens 30 days from the date of the order. And of course, there's been lots of litigation, and so far it's been enjoined, and it's now before the US Supreme Court, at least in terms of the scope of that injunction. So I'll turn it over to Vic to talk about the legal issues.
Sure, thanks, Amanda. So the primary theories underlying this alternative reading of Section 1's opening words seem to say that the term subject to the jurisdiction thereof. So Section 1 says all persons born ... in the United States and subject to the jurisdiction thereof are citizens of the United States and the states wherein they reside. And so the term subject to the jurisdiction thereof is understood to refer to the allegiance and longevity of the parents. So if the parents are here unlawfully and or temporarily, that makes the children not subject to the jurisdiction thereof within the meaning of Section 1, and thus not entitled to birthright citizenship, even though no one would deny they were born in the United States. And there's a lot of history. My brother knows a lot more about this, and I cribbed a little bit from stuff that I got from him in this Justia column I wrote last week. Amanda just referred to the Chinese American experience. But in the Justia column that Mary adverted to there, I just really wanted to focus on the bizarre textual interpretation here. Because the Section 1 doesn't say a word about parents. It says the persons born here. So it's self-consciously about place rather than parentage of citizenship. And then relatedly, it doesn't say born to parents subject to the jurisdiction thereof. It's the persons who are born who have to be subject to the jurisdiction thereof. And subject to is a term that really most naturally asks whether you're amenable to, whether you're bound by, not why you might be amenable to or bound by. It focuses on the fact of government power over you, not the basis of government power over you. So just as a textual matter, it just seems to me very, very, very far. Jamel Bowie kindly retweeted our column. I wrote it with my colleague Jason Mazzoni of Illinois, and he said, as these authors point out, that the arguments made by those who defend the executive order, they make Simone Biles' gymnastics look kind of ordinary. The flips and turns they have to undertake. And John Roberts in a case a while ago said, if you want to stop discriminating on the basis of race, you have to stop discriminating on the basis of race. Fine. If you want to take text seriously, you got to start taking text seriously. And so I just find it very implausible. I'm no expert on this as much as a lot of people are. I know some about it. I would be shocked if the Supreme Court were to buy this theory. I do think the court will probably end up taking the case, even if there's no split in the courts of appeals, just because the Solicitor General will ask, and it's a big issue that probably cries out for national resolution. I think the administration expects to lose. I don't think they count 5 votes on this the way they might on Humphrey's executor in the morning and the like. I actually think that they'll be fine to lose because they want to just show that they fought the good fight. And this is maybe it's going to be another Roe versus Wade kind of a thing, where this is a wrong thing the Supreme Court's doing. It's a wrong interpretation. It's a wrong policy. Blah blah blah. And so they get to use this as kind of a rallying cry for election after election, the way they did all the time until Dobbs was handed down. One final point I'll mention on this, this goes back to something I think it might have been Professor Emerson said in the first panel about defiance by the administration. We might be there yet. I'm not so sure we're close there yet. I mean, I'd like to believe that there's brinksmanship and there's when Vice President Vance said when he tweeted, and this got so much play, that judges don't have the authority to rein in legitimate executive power. Well, that's a truism. They don't. If it's legitimate, that's doing all the work. So I think people want to, obviously he's saying it for political effect. He wants to trigger people. He get that, but here's a good example where Trump has repeatedly said, we'll try to do it by executive order. If that doesn't work, then we'll see if we can amend the Constitution, signaling that he'll comply with whatever the Supreme Court says here. Now, there's obviously no chance you get 3/4 of the states to do this, so it's a non-starter. But to me, the question is, when the Supreme Court kind of slaps this theory down, it would be good if it's one of the first cases that comes along. Going back to Marty's point earlier, I don't know if there's going to be 50 cases in front of the Supreme Court, but maybe there's 10, and if they lose 6 and they win 4, they're happy with that. I'd like this to be one of the first ones, but maybe this will be packaged with another one close in time where the Trump administration wins. So maybe they affirm conventional views about birthright citizenship and jettison Humphrey's executor within a few months of each other. And that's part of the way the court tries to steer an even course.
All right, thank you both so much. I know we have some questions from the audience.
Yeah, I'll go first. So the Supreme Court is ripe to weigh in on universal injunctive relief, and Justices Thomas and Gorsuch have placed a new reliance on the 1789 English courts of chancery. I want to know, how do you think the other conservative justices are likely to rule, and what impact do you think this will have on the executives and the power to curb executive abuse over immigration policy?
Yes, so there are a couple of justices who've said that these nationwide or universal injunctions, they've asserted that they may be beyond courts' constitutional authority, or certainly maybe an abuse of their equitable powers. And just to be clear with folks who may not have followed this issue, a nationwide or universal injunction is an injunction typically against the government that says, government, you can't implement your policy not just against the plaintiff who sued, but against every similarly situated person. And so the objection is that these kinds of universal injunctions overstep courts' power. And a couple of justices have suggested that they would agree with that theory, that they want to prevent lower courts from issuing such injunctions. And then, of course, we saw just, I think, was it yesterday? I've lost track. Everything's coming so fast. But the administration asked the Supreme Court to review the scope of the injunctions in these birthright citizenship cases, because these were universal or nationwide injunctions. So in terms of what the court will do, I know Ketanji Brown Jackson actually concurred in something saying, last term saying, let's not move so fast. There are like some nuanced questions around this. I should add, I have written on this, so I'm not unbiased. The article I wrote said, and I'm now 7 years old, said, nationwide universal injunctions are overused. They should not be automatic. Every time you find a federal policy you don't like, district court, that doesn't mean it should be enjoined nationwide, but also that they are essential in certain kinds of cases where the plaintiff could not get complete relief without them, cases where it would be impossible to administer a patchwork injunction, think clean air or clean water. How can you administer a variation of the Clean Air Act in one way in one state and another way in a state where the water goes? And then third, in cases where people's constitutional rights would be upended because not each and every person could sue. And boy, is that birthright citizenship. Think about it. If birthright citizenship were to end for the next year or two before the Supreme Court were to rule on it, let's assume the Supreme Court says it's unconstitutional, the executive order, because birthright citizenship means what it says. That would mean for 2 years, every person who had a child, every person, not just the children of immigrants would have to find a way to prove that their child met the requirements, or the child would be denied any proof of their citizenship. And if they wanted to sue, each and every one of these parents would have to sue, like what, as they're like going into labor and delivery? Like, this would wreak havoc for states, for the federal government. I could imagine like pregnant women traveling to a state with an injunction in place to give birth, right? I mean, that would be the bizarre outcome of having anything other than a universal injunction. I think this case is a terrible vehicle to challenge universal injunctions, but I'm not going to predict what the court will do, because every time I do that, I regret it.
Thank you, Professor Frost.
So I agree with probably all or nearly all of that. In addition to Amanda's article, people might want to look at the work of Sam Bray. I think he's done some really good work. So they are overused. Let me give an example of a statewide rather than a nationwide injunction that I criticized at the time. I teach and write some in remedies, but I haven't written on this in law review articles, just in Justia columns. When California's Proposition 8 ban on same-sex marriage was challenged in federal court in San Francisco, and the lawyers there were the opposing lawyers in Bush versus Gore. They joined forces to represent the couples who were suing, claiming that it violated the 14th Amendment to deny them a right to marry. They didn't file a statewide class action, although they might have sought to. And District Judge Vaughn Walker in San Francisco enjoined the implementation of Proposition 8 statewide. And I said, wait a minute, why does complete relief could be given to these plaintiffs, to this couple, without broader relief? So Amanda's right. You can't have a remedy that leaves the plaintiffs shy of their rightful position. And sometimes, to make sure the plaintiffs get all they're entitled to, other people get something who aren't parties, but they get the benefit of that. But where you can craft a remedy that is fully respectful of the plaintiffs' rights, then you shouldn't go more broadly than that. Now, in the context of birthright citizenship, you can imagine a class action being hard to put together, and maybe that is a very compelling reason for having a nationwide injunction. One of the arguments against nationwide injunctions that's often made is it creates a terrible incentive on the part of the defendant to have to litigate very full-throatedly in that first case, for fear that if they don't, then they'll not have another chance to relitigate it. But that's not true in this case. The federal government will have every incentive to litigate this to the hilt, wherever it's litigated. So an argument is made sometimes that a nationwide injunction reduces the number of lower courts that may weigh in on something before the Supreme Court has a chance to review it. It puts a damper on percolation. Because it's not going to be an issue that bubbles up through multiple circuits at once. That may be true, and I think that's a factor that cuts against nationwide injunctions in a lot of cases, but I'm not sure that's such a big deal in this kind of context as well. So I'm actually more critical of nationwide injunctions than Amanda's article might be read to suggest she is. And so I think she's right. I think this would not be a good case for Thomas and others who don't like nationwide injunctions to try to make the stand. So I actually hope that that's not one of the issues that gets tangled up, because I think this is a very compelling situation for its use.
Just a couple of small things on this. First of all, to show where the court might be and how urgent this is, they just ordered that reply briefs on the universal injunction motion be filed by April 4th. So they're in no rush, and I don't think this issue is going to. And in that motion, that acting SG complains that there have been more nationwide injunctions and TROs in the past 5 weeks than in the entire Biden administration. But the court knows well why that is. I mean, look at the number of things that the Trump administration
and by the way, Marty, in that regard, this really went back to the Obama administration before Trump, before Biden. So this is something that ramped up after.
And it's coming up as Vic and Amanda suggest, it's coming up most in challenges to executive branch actions, red versus blue or blue versus red. And in those cases, in the vast majority of them, the Supreme Court is going to decide the answer to the question in 12 to 18 months. And so this, though not an unimportant question, and I do recommend Amanda's piece, it really is about what the status quo is during that interim period, whether there's a mixture of law being applied to various different actors, or whether there's a uniform rule, and if so, who's going to decide what the uniform rule is, the district court judge or the Supreme Court? Anyway, the other little thing is that Amanda suggested that this is covers only people born after February 19th, like 3 weeks ago. But it's very clear now from yesterday's filings, what was a little bit ambiguous before, which is that that's not right. It covers all persons born before February 19th as well. Section 2 doesn't, but Section 3 clearly does, which tells the agencies to get their practices in conformity with the President's view of the 14th Amendment. And the acting Solicitor General refers to this as an injunction that applies to millions of aliens nationwide. So I don't think there have been millions of births since February 19th, probably. So I think they're tipping their hand that this in fact is much broader than they made it seem like it is. And so I think today's order suggests there aren't 5 votes to rule for Trump at any time in the near future, I hope.
Yeah, on that point though, if the prospectivity of the order is not clear and kind of constitutionally required, then we're talking about millions upon millions of people who were born here, whose parents weren't here either lawfully or permanently. But then if you trace
probably half the people in this room.
If you trace that back to multiple generations, what do you do with the children of those people? Are they also disentitled to? So now we're talking about, maybe scores of millions, hundreds of millions of people.
This is on. Great. Thanks. It's been terrific. So I have 2 questions also about the birthright citizenship business. One smaller and one a little bit bigger. So as Marty has been pointing out to a number of us, the precise theory that the government is relying on to defend this executive order is, to put it charitably, evolving. And the latest position, as I understand it, in the briefing, is the attempt to explain the exceptions, the cases that don't fall within subject to the jurisdiction thereof, is that those are all cases where the primary allegiance was owed to another sovereign. Now, of course, there's still the problem of, are we talking about the people actually born here or their parents, bracketing that very large problem. I just wonder your thoughts on whether that actually works, because the administration is conceding that the children of lawful permanent residents have birthright citizenship, but if those lawful permanent residents are jus sanguinis citizens of a country like Japan, for example, I'm not sure that Japan would stipulate that because they have lawful permanent residency in the United States, that their primary allegiance is owed to the United States at that point, as opposed to the place where they are still citizens. And one can, sure, yeah. And so am I missing something here, or isn't there a kind of glaring problem with at least this iteration of the government's theory? And then the broader question is, Adam Cox and I have suggested that maybe the main problem with the EO, before we even get to the constitutional infirmity, is its inconsistency with federal statute. Now, I guess there's a theory that Congress passed a statute that said, well, whatever we think the Constitution means at any given point in time, the statute is just totally parasitic on that. That strikes me as a kind of high bar. There are lots of statutes, lots of jurisdictional statutes, 1331, 1332, that use the same language as the Constitution but are understood to mean something different. And here what we have is like decades of government practice and re-legislating of the same basic statutory rule on an understanding of its scope. And so it strikes me that, the court, for example, could hand a loss to the Trump administration without even reaching the constitutional question. And wonder what you think about that.
I was going to say that is what I think is the likely result if I had to predict what the court would do, just in terms of what it would prefer to do, but also what fits with its standard practice. There's a statute enacted in 1940 that tracks the language of the citizenship clause in the Constitution, that came into being with a history to it that has been interpreted ever since in a way that is consistent with universal birthright citizenship. That is, citizenship for all children, save the very narrow exception of those born to diplomats and those born in Native American tribes. But I should quickly add, there's a different statute that applies to give those children citizenship today. So I do think it would make total sense for the Supreme Court to take the case, rule only on the statutory question, and in a way leave that issue live for the nation to keep discussing and debating. I'm not sure that would be the court's goal. Maybe it would. And I see this issue being with us for a while as we think about this for a while as a nation. And while I sort of despair that we're debating this point that I thought, figured out post-Reconstruction and post-Wong Kim Ark, the 1898 case, I actually do hope this is a moment when books written by some of our panelists and thoughts and shared in blog posts and amicus briefs, et cetera, by panelists will help to educate the public about the value of this. I mean, the point we just had, if you went back and had to look whether your direct ancestor violated immigration law, I've looked, one of mine did. So my citizenship would be its suspect. Everyone, I mean, I would say half the room, as somebody suggested, would have to raise questions about whether they remain citizens. We're a country that's not about ancestry and lineage. You know, we to the degree we ended that with the end of slavery, and now we are American because we're here. And the idea that we'd start going back and interrogating our ancestors' lineage is terrifying and just un-American. So I hope we could have that conversation as a nation and reach the right goal, the right endpoint.
So really quick, I'm not an expert on the statute, and certainly it sounds plausible that this would be a good avoidance technique. Two quick caveats. So one, look at what they do with Title VI in affirmative action stuff. So, you can read these statutes as tracking the constitutional meaning all the time if you want to. I actually kind of hope they do reach the constitutional merits, because I don't think this is a question I would like to fester and to linger. And I think there'd be 5 justices on this court that would want to do this. It'd be in everyone's interest. It would kind of provide clarity to the country. They would be on record doing the right thing. They would be, faithful to a mode of constitutional interpretation and the like. Now, on your first, what you styled, Trevor, as narrower question, I do think that permanent residency doesn't kind of map on to allegiance as well as they might like. But you have other problems with the allegiance theory too. What about the Southern rebels during the Civil War? I mean, they were as non-allegiant as you could be. Does that mean their kids born during the Civil War are not covered by Section 1 of the 14th Amendment? Sam Desai, one of Akhil's students, has a blog post on Reason.com a few weeks ago that Steve Calabresi put that goes into that in some detail.
Right. We are over time, so
Sorry
please join me in thanking.
Usually I don't need to enhance my voice, but an attorney advisor in the Justice Department's Office of Legal Counsel and Associate Wilmer Cutler. He received a BA with honors in history from the University of British Columbia, JD from Columbia Law School, a fellow of the American Academy of Arts and Science, a member of the American Law Institute and Council of Foreign Relations. Okay. Secondly, Shalev Roisman, did I pronounce your name correctly? Okay. He's an associate professor of law and distinguished early career scholar at the University of Arizona Law School. His research and teaching focus on administrative law, presidential power, and constitutional law. He joined the University of Arizona from Harvard Law School. That's a trade school north of New Haven, Connecticut, in case you don't know. He was a Clemenco Fellow and a lecturer in law. Prior to that, he was an attorney advisor in the Office of Legal Counsel in the U.S. Department of Justice, an acting assistant professor of lawyering at NYU Law School, senior associate in litigation department at Wilmer Cutler, law clerk to Gerald Lynch and Robert Sack on the U.S. Court of Appeals to the Second Circuit. He received his JD magna cum laude from Harvard Law School, BA in history and economics from Cornell. Finally, Nick Handler is an associate professor of law at Texas A&M Law School. His research focuses on administrative law and civil procedure. He recently won the American Constitution Society's 2024 Cudahy Prize in Administrative and Regulatory Law. He is the co-recipient of the American Society for Legal History's 2019 Sutherland Prize for Best Article in the field of English legal history, and his scholarship has been cited by the DC Circuit and the High Court of Ireland. Before joining Texas A&M, he was a Thomas Gray Fellow at Stanford Law School. He clerked on the Second Circuit Court of Appeals for Judge John Walker, practiced litigation for 5 years at Paul Weiss in New York. He received his bachelor's degree in history from Yale College, his JD from Yale Law School, also holds an MPhil in history from Cambridge University, where he was a Gates Cambridge Scholar. So let's please welcome our guests. Trevor, why don't you go first?
Okay, thank you very much for the kind introduction, and thank you to the Pepperdine Law Review for the invitation. It's a great pleasure to be here with all of you and with my co-panelists. So I'm going to talk some about developments within the Trump administration, some of them abetted by a recent decision of the Supreme Court that have me concerned about malfeasance by lawyers and others within the executive branch and what might be done about it, where I think the risk of that is up and our ability to do something about it is down, across a couple of different topics. One is the process for, it was mentioned that I worked in the Office of Legal Counsel. I've written some about the role of OLC, where Shalev also served, in answering legal questions within the executive branch. And so there's early evidence to suggest that one of the distinctive things about this new administration seems to be a kind of decentering of OLC in the way that legal advice is provided within the executive branch. I don't think we know that this necessarily will be a long-term trend. But ordinarily, although there's no legal requirement that there even, constitutional requirement anyway, that there even be an Office of Legal Counsel, by practice, the statutorily designated opinion-giving function of the Attorney General is delegated to OLC, and it is historically the most important centralized source of legal advice within the executive branch. And in the main, the condition for OLC providing legal advice is that whoever is asking agrees to bind themselves to OLC's answer. There's skepticism from time to time about whether OLC really is a sort of credible interpreter of the law as opposed to just an apologist for the exercise of executive power. But to the extent that it's been a valuable office over time, it's because its advice is viewed as credible. When a president takes some sort of legally controversial action and his administration is asked, why did you think you had the legal authority to do it? The answer, we sought the opinion of the Office of Legal Counsel, is historically not a punchline. It's actually an effective answer to be able to point to the written opinion as a serious engagement with the legal question and as a basis, at least within the executive branch, for the conclusion that the action being taken is lawful. That's in part because OLC historically does not always say yes when an entity within the executive branch asks whether the action they want to take is lawful. This too, I think, is sort of hard to measure from the outside, and there's certainly ground for criticism that OLC at any given point in time has been sort of too willing to adopt pro-executive power theories of the law. But just looking at the publicly available record of written OLC opinions is a bit misleading here, because if the White House or any other element within the executive branch comes to OLC and asks for advice on the legality of some proposed program, if OLC has doubts about the legality of that, the most likely way it would go, and Marty Lederman, all of us here knows this more than anyone, having served for so many years in different administrations in that office, is that the relevant lawyers within OLC would say to the client, to the requesting agency or entity, we think we see some legal problems with what you want to do here. They would probably convey that advice orally. And what would happen next is there'd be a conversation of, why don't you tell us more about what you're actually trying to do? And let's see if we can identify a legally sound way to get roughly the place you want to go. Although your initial idea we don't think can be legally supported, but there may be some alternative. And if OLC concludes that there is, then if there's ever a written opinion that ever sees the light of day, it'll be about the legality of the second thing, not about the illegality of the first thing. And so the record of its legal advice is written legal advice is incomplete in that way, but it doesn't mean that the office hasn't historically served an important legitimating, but therefore also on some margin checking function within the executive branch. The price for OLC's legal advice being worth something is the belief that it would say no sometimes. And that's why White Houses that don't legally have to seek OLC's advice would seek its advice, not because they want to be constrained, but because they want to be legitimized when OLC says yes. So it's concerning that, as folks like Jack Goldsmith have observed, it appears that OLC was not involved in providing legal advice on the legality of maybe any of the initial round of executive orders that have been put out. Ordinarily, OLC plays a role in reviewing proposed executive orders, both for form and for legality. And if there were lawyers who looked at these orders, it's not clear that it was OLC. When asked this question, the White House press secretary said the White House counsel has concluded that these orders are lawful. In principle, there's nothing necessarily wrong with the legal advice that the White House receives when putting together executive orders come from the White House counsel's office as opposed to the Office of Legal Counsel. When I worked in the White House counsel's office, the people I talked to most often on the phone who were outside the White House were the lawyers at OLC. That's a sort of often close working relationship. But there are certainly risks. Just from the outside, the idea that the counsel's office is sufficiently distant from the loci of political power within the White House makes the risk that their legal advice will not really be sober, but will instead be sort of pure apologies for the exercises of presidential power. That risk is, I think, much greater. There also isn't the same kind of history to rely on. OLC, publishes its legal opinions, many of them. It treats them as precedents that it tends to follow across administrations. It will sometimes overrule itself, but it takes its own legal advice as a set of meaningful inputs the next time it addresses a legal question. It's not clear whether White House counsels would necessarily do that. It's not clear what attitude they would even take with respect to the legal questions put before them. And that raises concerns. It raises concerns about how the executive branch as currently configured in this administration is doing law outside of litigation. Are there mechanisms internal to this Trump administration which is insisting on kind of blind loyalty to, as Marty was saying this morning, just the president's policy agenda as effectively answering the legal questions that might come up? Can we have any faith in the integrity of legal interpretation happening within this administration, within the executive branch? I worry that the answer to that might be no. And I think that can have some pretty profound and bad downstream consequences. And I'll come back to that. I want to talk now about the impact of the Supreme Court's decision last summer in Trump versus United States. This, of course, is the case addressing the scope of a president's or former president's immunity from criminal charges. So just a reminder, I think everybody knows about the case, but the court concluded or sort of reached a conclusion in the case that had three components to it. One is that a former president facing criminal charges for conduct while in office is absolutely immune from criminal charge for actions taken within the president's exclusive and preclusive authority. This is the language from Justice Robert Jackson's concurring opinion in the Youngstown case. The idea that within the president's power overall, there's a sort of core of his power that is so exclusively his that no other government actor can act upon him when he exercises that power. And within that core, therefore, ipso facto, if he can't be regulated in any way, in a prospective way, then he obviously can't be prosecuted for how he exercises that power. The court presented that idea as sort of flowing straightforwardly from the Youngstown framework itself. And I think in principle, that's about right. Last spring, before the briefs were filed in the case, I wrote a short essay saying as much, that I think we already know that there is a sort of category of presidential conduct that can't be implicated in criminal prosecution because it is exclusively and preclusively granted to the president. The trick is how broadly you understand that category, not whether it exists. Second category, at least what the court said was at least presumptive immunity for all acts falling within the outer boundary of the president's official responsibility. This notion of an outer boundary as official responsibility was drawn from the Nixon versus Fitzgerald case, which is about presidential immunity from civil suits seeking money damages, a case that the court handed down in the early 1980s. And then the court went out of its way to emphasize, we're not making the president a king because, of course, a king above the law, because, of course, he has no immunity for conduct taken while in office that was purely in his personal capacity, as though there was someone suggesting that the answer to that question might be anything else. Even Trump's own lawyers in the case, now has he been confirmed? The nominee to be Solicitor General. Is Sauer confirmed? Is Sauer confirmed yet? Okay. The about to be Solicitor General of the United States representing Trump before the court in that case actually conceded that some of the charges against Trump in that case involved only personal conduct. The majority was not willing to make that concession in the case, though Trump's lawyers were, but that category, no immunity whatsoever. At the time the case was handed down, I think most attention was focused on the second category, this pretty sweeping, at least presumptive, maybe absolute, maybe irrebuttable, but at least presumptive immunity for all acts taken within the outer boundaries of the president's official responsibility. Justice Sotomayor said in her dissenting opinion, you don't need to pay attention to anything else in the case because this is going to cover it all. And she took the presumption to be effectively irrebuttable, even if in principle it might be rebutted. And so she said, that's the rule that matters. And I think if all we were talking about is the extent to which a former president can be criminally prosecuted for his acts while in office, I might agree with Justice Sotomayor that that rule is going to be the sort of operative on the ground immunity rule. That's the part of the court's decision that would have been sorted out on remand had the case continued towards trial. But the thing that concerns me by far the most about the case is the first category and the way the court described the president's exclusive preclusive authority. Again, the idea that there are such things is not an innovation of the Trump decision. Jackson referred to it back in Youngstown. The Supreme Court has decided cases like the Zivotofsky case that held that the president's power of recognition, the power to recognize foreign governments, which entails obviously then the power to recognize their boundaries and recognize their capitals and that kind of thing, that is a power, although nowhere explicitly in the text enumerated, granted to the president and granted so exclusively to the president that Congress may not regulate the exercise of that power whatsoever. The court had decided Zivotofsky, a decade before this immunity case. And so the idea of that, I think, is familiar and not by itself controversial. And although Zivotofsky was not about a criminal prosecution, it must be the case that if some conduct falls within the exclusive and preclusive domain of a president's power so that Congress can't regulate the exercise of it in a going forward way, then I think it is the case, therefore, for that same reason, that Congress couldn't prosecute the president for exercising that power after the fact. I think that follows necessarily. But the big thing is what the court said about that. One set of the charges against Trump had to do with his use or attempted use of the Justice Department to put pressure on state election officials in states like Georgia to investigate supposed irregularities in the outcome of the election in 2020 and even to change their count. And what Trump was doing was, among other things, pressuring members of the leadership of the Justice Department to open investigations in these states, to send communications to state officials to put pressure on them. And the allegation in the criminal complaint is that this was all a sham. There was no lawful basis for any of this. So it was abusing his power over the executive branch over the Justice Department in ways that constituted federal crimes. And what Chief Justice Roberts said for the majority is that the fact of the president's power to remove high-ranking officials within the Justice Department, those whom he has appointed, so that implicates the removal line of precedence, right? The fact that he has that is connected to and implies a broader exclusive and preclusive power that is also connected to his responsibilities under the Take Care Clause of the Constitution, such that the president has an exclusive and unregulable power to direct the investigative and prosecutorial decisions of the Justice Department. The language that the court used here is more sweeping than any language that the court has ever used with respect to these topics. The president has, quote, the exclusive authority over the investigative and prosecutorial functions of the Justice Department and its officials, and therefore cannot be prosecuted for anything relating to that, even if the investigations that the president is ordering be opened were known to him to be a sham, even if there's no legal basis for them whatsoever. So in earlier cases, for example, the court has held that Congress could limit an agency's exercise of enforcement power if Congress wanted, either by setting substantive priorities or by circumscribing an agency's power to discriminate among the issues or cases it will pursue. It's hard to see how that reasoning survives what the court said about the president's power to direct the investigative and law enforcement functions of the Justice Department. It's hard to see how this would be limited to the Justice Department. There are other executive agencies that are responsible for enforcing the law, especially on the civil side, and this rationale seems to cover all of it and place it all not just as something that the president has some responsibility for, but that he has exclusive authority over in a way that Congress can't regulate it at all. That means that the president couldn't be prosecuted at all for those things. Those charges in that case, no matter what happened on remand, could not be pursued. But that language has implications way beyond criminal prosecution. I think it gives the executive branch enormous enforcement discretion. If this were the rule in place when Obama's prioritizing of different categories of cases in the immigration context were challenged in the latter years of the Obama administration, he would have won summarily. There would have been no basis whatsoever for challenging that. I think it has huge implications for Congress's ability to conduct investigations. The kind of executive privilege arguments that the executive branch will be able to make when the inquiries that a congressional committee are making are in this area just got way, way stronger. And I think it makes it perhaps impossible to reach lawyerly malfeasance by the president's subordinates. And that's what I want to emphasize as my last point here. It's been said by some commentators about the decision in the months since that, well, maybe the president is absolutely immune in these different ways, but that the force of that holding is going to be blunted by the fact that in order to do anything, the president needs really to take action through his subordinates. He needs others in the executive branch to follow his orders. And that's true. There's virtually no aspect of presidential power that's a one-man job. This, however, I think this part of the decision has been underappreciated for its implications for the idea of subordinate liability. Go back to what we've already known from before this case was handed down. From cases like Youngstown and Zivotofsky, we've known that if a subordinate of the president is taking actions in order to execute the president's will with respect to something over which the president has exclusive and preclusive authority, then that subordinate cannot be regulated. That's what Zivotofsky is about. The statute at issue in Zivotofsky did not purport to regulate the president. It required the Secretary of State to list on the passport of a person born to US parents in the city of Jerusalem. The practice of the government across administrations had been to list that person's place of birth as Jerusalem rather than Israel, so as to maintain a position of studied ambiguity on the status of Jerusalem. And the statute said you must list Israel if they request it. That statute regulated the Secretary of State, not the president directly. Yet it was held to be unconstitutional as an infringement on the president's exclusive and preclusive power of recognition. So when a subordinate is exercising that presidential power, they are as unregulable as the president himself would be in doing that. That is a principle emanating from the logic of Youngstown, having nothing to do with criminal immunity. But if we apply that principle to the language that Roberts used about the president's unregulable authority to oversee the actions of the Justice Department, I think we have an immunity not just for the president, but for all subordinates carrying out his directions. And so it's not just that the president couldn't be criminally prosecuted for ordering a sham investigation or indeed even a sham prosecution of his political rivals, but the United States attorney who opens that investigation, who brings those charges, is just, in my view, under the logic of this opinion, is just as unprosecutable, is just as unsuable. I think in money damages, if we're talking about this being the exclusive and preclusive power of the president, then the background rule of qualified immunity would not apply. We're talking about absolute immunity for the president's subordinates. And I think those subordinates, if they're lawyers, would be immune also from bar discipline. OLC has taken a position that state and DC bar disciplinary codes might be preempted by federal law to the extent that what the official in question is doing, the federal lawyer in question is doing, is authorized by federal law. Well, here it's not just authorized by federal law, it's executing the president's desires with respect to his exclusive and preclusive power. And so the argument of preemption would be very strong. So think about past instances of abuses or irresponsible activity by Justice Department lawyers, think about the torture memos, et cetera, and think about how bar disciplinary proceedings were brought to bear. Think about just last year, the disciplinary proceeding brought against Jeffrey Clark. I think if that proceeding had not been opened until after Trump versus United States was decided, that Clark probably would have succeeded in having those proceedings dismissed on grounds of categorical immunity. I do not believe that Chief Justice Roberts intended all of this. I think he wrote an immensely sloppy opinion. But I don't know that we're going to see litigation in this space. Instead, what I think we're going to see is internal lawyering within the executive branch, not maybe emanating from the Office of Legal Counsel, but emanating, say, from the White House counsel's office that provides guidance to prosecutors, be it Ed Martin, if he becomes U.S. Attorney in the District of Columbia, or others in Maine Justice, to do the bidding of the president, secure in the knowledge that they will be absolutely immune in taking those actions. And it's a deep concern to me. And I hope that by the time I write this up, I'll have at least some thought about how to avoid that outcome, but I haven't gotten there yet. Thank you.
Okay, thanks, Professor Morrison. Next is Professor Roisman.
All right, well, thanks so much, and thank you very much to the organizers for inviting me. It's a real honor to be on this panel and among this great group of scholars. So I think my remarks are going to follow very well on Trevor's and also on some of the conversation from the first panel this morning. And so I'm going to talk about the role of the president in the current doctrinal era, which I think of as the era of exclusive powers. And first, what I'll lay out is kind of one way to explain, I think doctrinally speaking at least, what the current Trump administration is up to and how it's been enabled by the recent court's jurisprudence. And then I'm going to lay out a couple ways we might want to respond doctrinally. And I should say just at the outset that my focus here is on legal doctrine. There are, of course, political explanations and there are appropriate political responses. And so I don't mean to say that the legal responses should be the thing we should be most concerned about or that is most explanatory, but it is the thing that I know more about. So I'm going to talk about that. Okay, so it seems to me that the great kind of innovation of the Trump administration has been to take what the Supreme Court has said about exclusive powers seriously. And so during President Trump's first election campaign in 2016, there was this viral line that the press takes him literally but not seriously, and his supporters take him seriously but not literally. And I think what the Trump administration is doing is taking the Supreme Court literally. And I don't think the court ever expected that, truly. So the Roberts Court has been kind of famously formalist in its separation of powers jurisprudence. And in its contemporary form, this basically just means a preference for rules over standards in resolving disputes between Congress and the president, and then an ostensible commitment to deriving the content of those rules from the original meaning of the Constitution. And so the way formalists tend to view the Constitution's allocation of the separation of powers, which is the kind of Schoolhouse Rock version, which is that the Constitution allocates distinct bundles of power to each branch. And so, this will be familiar to everyone. The president gets the executive power, Congress gets the legislative power, judiciary gets the judicial power. And so when you're trying to resolve a dispute between the branches, this leads to a straightforward method of resolving them. You just figure out which branch has the exclusive power. So if the Constitution divides up exclusive powers to each branch, those are distinct and exclusive, meaning if one branch has it, the other branches do not. You just find out which branch has exclusive power, and that tells you the answer of who should win in one step. That branch has power, no other branch can have such power. And so they've relied very heavily on this notion of finding exclusive powers. I'll just note as an aside that even formalists admit that exclusive powers sometimes overlap, which I think is a major, major flaw in this method. But if people want to ask about that, I'm happy to talk about it, but I'm just going to put that to the side for the moment. So in principle, I think this mode of resolving disputes by finding exclusive powers shouldn't have any sort of a priori preference for the president or Congress. You would just approach each issue as they come, and you would figure out which one had exclusive power. In application, what the recent Supreme Court, the conservative formalist court, has done is prefer the president over Congress pretty consistently. And because their method requires finding that a branch has exclusive power to prevail, that's what they've done. And so when there's a dispute between the branches, they say the president wins. Why does the president win? Well, it turns out the president has exclusive power. And the consequence of this, as Trevor said, is that if the president has exclusive power, then that means Congress is disabled from acting upon the subject. This comes from Jackson's famous Youngstown concurrence that I'm sure everyone in the room has read, which was meant to be, I think, in two key parts of the Youngstown concurrence that should not be forgotten are, number one, it was meant to be pragmatic and non-functional in reasoning, and number two, it was meant to be pro-Congress. And the way I think the current Roberts Court has interpreted it has inverted that. It's number one, formalist, and it's two, pro-presidential. But I will say that I think Jackson kind of unintentionally enabled what the Roberts Court has been doing in how he phrased Category 3. So what he said, as Trevor said, what he said in Category 3 was not that the president always loses. He said that his power is at its lowest ebb, and that he can only prevail if his power is exclusive, conclusive, and preclusive, which disables Congress from acting upon the subject. And I don't think Jackson thought the court would find this very often, but what the Roberts Court has said is basically, okay, if that's how the president wins, that's how the president wins. So the president wins here. Why? Because he has exclusive power, and that disables Congress from acting upon the subject. And this was true in Zivotofsky versus Kerry. This is from 2015. That, as Trevor said, it's a conflict between the president's power of recognition and Congress's power to regulate passports. So Congress had said that if an American citizen is born in Jerusalem, they could choose to have their passport say Jerusalem, Israel, rather than Jerusalem. And the president said, no, that violates my decision not to recognize Jerusalem as part of Israel. And what does the court say? Well, they say the president's power is exclusive. The recognition power cannot be limited by Congress's passport power. We see this in Saylor law, which Marty talked about this morning. That's a conflict between the president's power over removal and Congress's power to structure offices. How does the court resolve it? Well, again, the president wins. Why? President has exclusive power over removal, so Congress's office structuring power can't interfere with that. And then we see it most glaringly, as Trevor said, in Trump versus United States. That's the president's power over law execution versus Congress's power to criminalize conduct. Again, what does the president say? Well, in the zone of exclusive power, Congress's power is limited. The president has absolute immunity. And so to take just Saylor and Trump together, what the court has said, in essence, is that the president has exclusive power to control law execution, which, in the words of Jackson's Category 3 analysis, disables Congress from acting upon the subject. Now, I think this claim that the president has exclusive power over law execution simply cannot be reconciled with widely accepted views, even among the formalists, about Congress's control, Congress's ability to structure the executive branch by, for example, creating offices, creating departments, giving defined subject matters to those officers and departments. Congress can choose to give an authority to the State Department or to the Department of Defense that obviously interferes with how the president might otherwise wish to structure the executive branch, but everyone agrees that Congress can do that. Moreover, Congress can impose procedural requirements on how execution of the law is done. Have people heard of notice and comment rulemaking? Have we heard of on-the-record adjudication? Those are all things that interfere with ways the president might otherwise wish to structure execution of the law. So I think all these actions quite obviously interfere with the president's ability to control execution of the law. And by the way, it's not clear why Congress could even impeach the president for conduct within the exclusive zone if it's clearly disabled from acting upon the subject. So I think there has just been this fundamental contradiction in the notion that the president has exclusive power over law execution, but Congress can do all the stuff that everyone accepts Congress can do, even though it interferes with the president's exclusive power. And I pointed this out in prior work to show how, I thought this just showed a cool inconsistency or incoherence in formalism, and maybe that would get them to kind of abandon it. They haven't listened to me yet. We'll get to that. I did not think that the court would abandon the inconsistency and just stick with the exclusivity of the president's power. So enter the Trump administration, the second Trump administration, and I think what the second Trump administration is doing is just taking the court at its word. So I think if the president's power, and again, I don't believe this is true. I don't think the president has exclusive power to control all law execution. But if he did, if his power were truly exclusive, if all the executive power belonged to the president, then I think it would seem true that the president can fire whomever he wants. I think it would seem true that the president could hire whomever he wants, whether they're a principal officer, whether they're an inferior officer, whether they're a civil servant with for-cause protections. If he truly can control all law execution, he should be able to pick them, he should be able to get rid of them. I think it would even probably be true that the president could choose not to spend money He could freeze OMB funding if he thought it was necessary to faithfully execute the law. He could eliminate USAID. That's a department in the executive branch. If he thinks that that's not the way the executive branch should be structured and he can fully control the execution of the law, then USAID is part of the State Department now, because that's how I think it should work. And I think he could do all of these things because he has exclusive power. And so I think as unprecedented and as aggressive as what the Trump administration is doing, it seems to me the court has enabled this by stating explicitly that the president's power is exclusive. And so, as Trevor said, I don't think what the Trump administration has done in recent months is what the conservative majority on the Supreme Court intended, but I do think it's kind of what they said. So I think there's at least two ways, and I'd be welcome hearing other ways, but I think there's at least two ways as a matter of legal doctrine that we might want to respond to this. So the first would be to fight the premise, and by this I mean we could try to encourage the court to abandon formalism as its preferred method of resolving separation of powers disputes, and I think there's good reason to do this. I think there's good reason to do this because formalism has never been able to construct a coherent rule of prioritization that tells us which branch to prevail when both branches have power to act and come into conflict. It has no clear rule of prioritization when both branches have power to act and come into conflict. That is in areas of overlapping power. Justice Thomas has admitted this. This is no small matter because basically all the disputes we care about arise in areas of overlapping power. So if we think about for-cause removal protection, sale of law, that's the president's power to remove versus Congress's power to structure offices. If we think about Zivotofsky, that's the president's power to recognize foreign states versus Congress's power to regulate passports. If you just think about that for a second, if the president has power to recognize foreign states, that implicitly would include the power to decide how to determine the boundaries of those states on passports. If Congress has the power to regulate passports, that would implicitly include the power to decide how to denote places of birth on those passports. They both have power over places of birth on passports, and they just come into conflict. There's no formalist rule in the original meaning that tells us who should prevail over that. This is also true of Trump versus United States. That was the president's power to engage in official acts versus Congress's power to criminalize conduct. Again, they both had power in that dispute, and there is no formalist rule that tells us who should prevail. All of these disputes, and basically all the disputes that we care about, arise in areas of overlapping power, and formalists have just never developed a coherent rule or consistent rule that tells us who should win in those cases. Instead, what it has done is it basically just arbitrarily picks a side, usually it's the president, and they say, oh, actually there was no area of overlap because this branch had exclusive power. And that is just a way of denying the fact there is overlapping power. It's not a way of resolving a dispute in that power in any consistent or coherent way. And I think that's led us to exactly where we are today. And so my first response would be to convince the court that there's no method here in the formalist world that can help resolve these disputes in the way they want, and so we should abandon it. What should we do instead? There's lots of theories about how to resolve these disputes. I prefer a non-categorical approach using interest balancing, where we would accept that both branches have power to act. One branch's exercise of its authority interferes with or infringes upon an exercise of power by another branch. And you would ask, well, does that branch have a sufficiently strong reason to do this? This requires balancing. This is how we do rights. It's subjective. It's got all these problems, but I think it's better than any of the prevailing alternatives. Okay, that's the first approach. We get the court to abandon formalism. The second approach is that we accept that the court is committed to formalism, and we say, okay, let's see if it goes all the way. Say the court says, fine, the president has exclusive control over a law execution, and Congress can't limit it. What do we do then? I don't think, by the way, the court will go this far, but I think it's worth thinking about what we should do if it does. So what follows from this? I think that the conventional view is that if the president is exercising exclusive power and Congress cannot limit how the president exercises that power, then the president's action is essentially lawless. He can do whatever he wants. And I want to resist that. I want to resist that because I think that the president is under legal obligations that derive from Article 2, even when he's exercising exclusive power. And so what I want to say is that even if Congress cannot limit the president's law execution power under its Article 1 authority, Article 2 directly limits how the president exercises power. It imposes procedural obligations on the president. And what do these procedural obligations include? Well, I've laid this out in prior work, but I think they include at least 3 duties. One, the president must be public interested rather than privately interested in motivation. 2, the president must honestly believe any predicate conditions are met before exercising power based on those predicate conditions. And 3, the president must deliberate. That is, gather relevant information and make a considered judgment before exercising power. And these are procedural requirements that I think are imposed directly on the president by Article 2, and they form a body of law that I've called presidential law in the past, which was a failed attempt to mimic the term administrative law as a procedural body, a set of rules that bind execution of the law, but not of agencies, but of the president. And I derive these obligations from, pretty conventional sources of constitutional interpretation, the text of Article 2, internal executive branch legal interpretation, as well as a number of Supreme Court cases across a range of domains. And I'll be clear here, people might be skeptical. I don't remember the Supreme Court ever saying the president's under procedural obligations, because it hasn't said that explicitly, but I think it is implicit in a range of cases across non-delegation domain, executive privilege, deference to foreign affairs. Why does the court defer to the president on foreign affairs issues? Because the president has better access to information. I think that presumes he'll gather information and consider it before acting. That's just one example. And so I think even if we end up in the sort of dark place of full executive power, of full exclusive control, where administrative law is optional, I think the Constitution is not silent. I think the president is still under procedural obligations in that world. And I think those obligations would have some bite in some of the things the Trump administration has done. So if you just take, for example, the change to indirect costs for NIH funding, I don't think they considered relevant information and made a considered judgment before imposing an across-the-board 15% cut. I think it violated the duty to deliberate. I think firing all these probationary employees, ostensibly for performance issues, when there were none, violated the honesty and deliberation requirement. I think a lot of what DOJ has done would violate the duty to deliberate. And I haven't fully thought through how this should apply to the president's exclusive powers, and I want to be clear, I'm wary of overly procedurally constraining the president. I don't think that he is under the same obligations as an administrative agency under Article 2. I think these duties are fairly minimal and they are contingent on the circumstance, but I don't think they're empty. I think it's a body of law with some bite. And I think it's at least possible, I'm not going to predict this, I think it's at least possible the court might be attracted to this sort of thing. If it's going to go as far to say as basically the president has no substantive limits on his power, then it's very common to say there's broad substantive limits. Well, maybe let's impose some procedural limits instead. And so I think there's some room here for the court to save face if it wants to go the exclusive powers route by saying the president has broad substantive power, but there are some limits in how the president exercises that power. And then I'll sum up really quickly. So I think, again, what the Trump administration is doing is taking the court at its word. I think it's leading to a dramatic and deeply unsettling for many of us landscape of broad exclusive power that disables Congress from regulating the president. I think this world was clearly enabled by the Supreme Court's precedent, and it's not clear how the court will respond. I think there's two ways we might wish it to respond, or I might wish it to respond. One, by abandoning the formalist method that got us here and adopting interest balancing, hopefully, citing to my law review article on that. And second, I think we could accept we're in this era of exclusive power, but find that the procedural limits bind the president even in the formalist world. And candidly, I'm hoping for the former, but I think the latter would be better than nothing. And that's probably about as good as we can do these days. So thanks very much.
Thanks, Professor. Finally, we have Professor Handler.
Get this on. Thank you. I want to echo what Shalev said, that I'm really grateful and humbled to be here with so many eminent scholars, and and thank you to Matthew, to Jacqueline, to Professor Johnson, Professor Pushaw for organizing this conference. I think it's really excellent and really timely. So with my 10-ish or so minutes, 15 minutes, I'm going to try to take us kind of like down the chain of command, past the president, past the executive office of the president, past the principal officers, past the inferior officers. And I'm going to use my time today to talk about what has been an area of research interest for me recently, which is the federal civil service, and in particular the role that collective bargaining and labor organizing by federal civil servants plays in restraining presidential abuses. So with my time, I'm going to try to cover sort of like two big points. First, I'll try to lay out some ways in which collective bargaining can constrain presidential power as a general matter, and then I'm going to try to flag some issues that I think are going to be specific to the second Trump administration, both things that we've kind of already seen and also some things that I sort of predict we'll see in the not too distant future. So first, let me kind of give you a bit briefly describe how civil servant labor rights work as a general matter before I talk about sort of the Trump specific stuff. So the Civil Service Reform Act of 1978 gives federal employees the right to form unions and to bargain over the, quote, conditions of their employment. And this right is pretty broad. It covers a lot of employees and it can end up interacting with some important policy areas. So just to give some sort of context here, there are about 1.2 million federal civil servants that are represented by a union. It's about 60% of the federal workforce. There are hundreds of collective bargaining agreements in place governing the rights, the workplace rights of those employees. And there are like thousands of labor litigations and arbitrations per year ordinarily on a range of issues. And these labor rights can govern some pretty important subjects. So just to give like sort of a few examples, what types of searches can a Border Patrol agent be required to conduct? Can an administrative law judge be required to grant or deny a certain percentage of applications for Social Security benefits? Can asylum officers be required to adjudicate a certain number of asylum claims per year? So these are questions that have really important policy implications and get to the heart of some pretty important aspects of administrative lawmaking. So I'll just give you a quick overview of some of the key tools that unions use to restrain presidential power, and then I'll talk about some implications for the Trump presidency. So I'm going to break up kind of. The statute is very technical. There are a lot of different labor rights and you're cashed out into these very long collective bargaining agreements that could run to the hundreds of pages. But I'm going to sort of break up labor rights generally into kind of two buckets. So there's sort of the negotiation. Bucket one is kind of like the negotiation and enforcement of contractual rights that govern the sort of workplace rights of employees. And then bucket two are kind of the rest of the powers that federal employees enjoy to kind of form unions, to sort of collect dues and then to use the unions and their resources to sort of advocate and litigate on a range of additional issues. So first, on the first bucket, so the Civil Service Reform Act gives unions a lot of power to negotiate and enforce contracts that dictate how their employing agencies can and cannot manage them. And there are a few ways that this can constrain presidential power, and I'll just talk about some big ones. So first, unions can and often do use contracts as a constraint on what some scholars have called sort of structural deregulation, sort of the deliberate attempts by the presidents to sabotage or to hamstring an agency's execution of its statutory mission. So one of the main ways that presidents can shift enforcement and policy priorities is by degrading working conditions at agencies whose missions they oppose, right? So they might increase work hours, decrease resources, impose lots of burdensome conditions on personnel at agencies they want to hamstring, like say the EPA or the Department of Labor. And these are precisely the types of issues that collective bargaining most directly addresses. What hours you work, where you work, what roles you can be required to perform, what resources you can demand in order to do your job, what physical comforts you're entitled to. So collective bargaining is often the last and most important line of defense against structural deregulation at an agency. One aspect of this you might have seen in the news recently is remote work, the ability of workers to sort of perform their jobs, not on site at the physical headquarters of the agency, but there are dozens and dozens of other issues. So there's sort of structural deregulation. Second, unions can also use contracts to sort of reshape critical management tools. So agency heads have lots of kind of tools that they can use to incentivize civil servants to behave in certain ways or to favor certain types of decisions over others. So performance reviews can incentivize certain outcomes through favorable performance ratings and punish other outcomes through unfavorable ratings. Productivity quotas can make certain types of decision or certain courses of action much more burdensome and much more difficult than others. And collective bargaining allows employees to challenge and to reshape those directives in all kinds of ways. So unions often bargain, for example, over how their performances can be evaluated or how burdensome their workloads can be, how much work you can actually require sort of employees to do on a daily basis. And in addition, union contracts often very substantially sort of expand the rights that civil servants enjoy in disciplinary proceedings. So what you can be disciplined for, what process you're entitled to, what penalties you face. So these are things that are often detailed in collective bargaining agreements, and they often go far beyond what might be provided for in, say, civil service statutes that govern kind of like the hiring and firing of federal workers. So that's kind of the first bucket, sort of like the ways in which contractual rights can preserve the integrity of an agency's mission. And then there's the second bucket. So beyond contractual rights, unions also have other kind of practical and political tools that they can use to reshape executive branch policy. So a big one is like they can pool money and resources that enable them to do things like develop a really sophisticated bar of labor attorneys that litigate not just contract specific or labor specific disputes, but they might litigate in other areas like civil service laws, whistleblower complaints, discrimination claims, and proceedings before the EEOC. They might also litigate constitutional claims that affect the operation of the executive branch and therefore the working conditions of their members. So unions are very sophisticated players in litigation governing kind of control of the executive branch. And again, I'll talk about this in a minute, but you may have seen the names of major federal unions appearing in very high profile cases in the news recently. So there's litigation. In addition to litigation, unions also can lobby Congress for changes to agency policy. They can engage in kind of like sophisticated messaging campaigns through the press, through social media. So in other words, like labor can act as sort of a sophisticated and a coordinated constituency inside the executive branch that to some degree at least can counterbalance the bully pulpits and the formal legal power of the president and maybe move public perception and move the political decisions of the other branches on key contested questions of sort of executive branch control. So labor matters, and I think it's been an increasingly important force in the battle for control of the executive branch for the past couple of decades. So let me just close with some thoughts on what I think labor's role, has been and will continue to be in the second Trump administration. So generally, I mean, I think that the role unions play under the Trump presidency are going to fit largely into the same buckets that I just outlined. They're going to act as both enforcers of federal labor rights and also as broader engines of political mobilization in sort of these broader political contestations over kind of the scope of the president's sort of control of agency operations. So on the first bucket, labor rights. I'll just preface this by saying that historically labor rights have played arguably a more important role in controlling the federal workforce than civil service laws have. So civil service laws kind of are related to but distinct from labor rights. Civil service laws regulate primarily major personnel actions. So like hiring, firing, suspension, demotion, and labor rights govern everything else, basically how employees can be sort of like managed and overseen on a day-to-day basis. Historically, firing and demotion are very powerful tools, but presidents have been reticent to use them on a mass scale to discipline the federal workforce because firing is costly, it's procedurally very difficult and burdensome, it can disable key government functions, and as a result, it can become quite politically unpopular because it disrupts some fairly important aspects of government operations. And so historically, presidents have preferred to incentivize bureaucrats to implement their agenda through management tools rather than through just sort of blunt threats of firing or demotion. This has been true at least since the Nixon administration, and it was also largely true during the first Trump administration. Obviously, the second Trump administration has been much more willing to engage in mass firings. We'll talk about that in a second. But even so, I think it's likely that we'll still see big labor fights in the future, and there are a few reasons for this. So first, the president can't fire the entire federal workforce or even most of it. And that's because, some duties are statutorily required. The administration's been clear, at least so far, that it's not going to discontinue functions that are explicitly required by statute. And there are other functions that the Trump administration does want to continue. I mean, immigration enforcement is a sort of a prime example of this, but there are others, I imagine, that are just going to come under increasing political pressure. But we've already seen them walk back, some firings and, for example, air traffic control. I mean, things that people just kind of rely on as like sort of incidents of modern society. So you're not going to have all or even most of the federal workforce be fired. I mean, the upper bounds of sort of what I've heard estimated is like 700,000 federal employees. That's an enormous cut to the federal workforce, but it would still leave you with about 1.7 million, federal workers that then the Trump administration is going to have to try to sort of direct and manage. In addition, like firing is hard. It's often there are a lot of procedural requirements that you have to go through. There's a process before the MSPB. There are specific showings required by statute that you have to make. So we've already seen a number of mass firings reversed by district courts, and I think that the procedural difficulty of firing is going to continue and sort of slow down the pace of kind of like mass attrition. So even if the administration succeeds in firing large numbers of workers, I think it'll still likely have millions of workers that it needs to manage and control. And I imagine that as the cuts slow down and the administration drags on, we're going to see a lot of labor litigation. And so I think that labor is going to have a big impact on a number of policy areas. I'll just give a couple of examples based on sort of like what the Trump administration has said it's focused on and what areas of conflict were in the first Trump administration. So one is immigration law, particularly immigration judging and enforcement. So a lot of presidential administrations, including the first Trump administration, use labor and management tactics to influence immigration policy. There's a lot of ground level enforcement that's influenced by collective bargaining. A lot of the core duties of ICE and CBP intersect with contractually negotiated rights in important ways. Management policy has been an important tool of trying to sort of manipulate the outcomes or influence the outcomes of removal proceedings by immigration judges. The Trump administration had a lot of very high profile and legally complex disputes with the union representing immigration judges during the first administration. So I think immigration is going to be one area where we continue to see a lot of labor conflict. Environmental policy is another one. The EPA union in the last year of the Biden administration just negotiated an extensive new collective bargaining agreement that, among other things, seeks to preserve scientific independence and scientific integrity at the agency. That's almost certainly going to be the subject of major labor litigation. At pretty much every agency, I think we're going to see a range of labor fights around working conditions, forced attrition. I mentioned the sort of remote work policy as one example, but there are going to be many others. The Trump administration has already purported to rescind the CBA governing working conditions for TSA agents. I imagine we're going to see a lot more unilateral rescissions of union contracts in the coming months. And so these are just like sort of a few examples of what I imagine are going to be very many labor disputes over the coming years. And there are, alumni from the first Trump administration now serving high up in the second Trump administration who have spent at this point 8 or 9 years thinking in great depth about the ways that they can sort of challenge various provisions of federal labor law in order to increase the president's control over the federal workforce. And so then, lastly, briefly, on the second bucket, unions, it's sort of the broader role that unions play in kind of challenging executive power, presidential power. Unions have also been playing a really important role as communicators and enforcers of other laws in the sort of early weeks of the Trump administration. So, on the enforcement and litigation point, unions haven't just been litigating labor-specific issues. They've also been litigating a wide range of issues governing the sort of affecting the control of the executive branch under other civil service laws, the Administrative Procedure Act, various constitutional provisions. So just to give sort of like a few examples of the very many ongoing lawsuits where unions are playing a major role, the lead plaintiffs in the litigation involving the dismantling of USAID, include the American Foreign Service Association, and that's raising a number of constitutional challenges, the Take Care Clause, Administrative Procedure Act, the litigation involving NTU versus VOTS, litigation involving the dismantling of the CFPB, again, raising issues under the Administrative Procedure Act, the Vacancies Act, and there are a number of others that we can talk about in the Q&A, but unions are playing an active role in litigating not just labor-specific issues, but a broad range of statutory and constitutional challenges to executive power. And then outside of litigation, unions have been playing, I think, a pretty critical role in organizing and communicating with the public in response to sort of this rapid attack on the administrative states by the Trump administration. So, they've been doing a lot in the press and through social media, communicating critical information about what agencies are being cut, what functions those agencies perform, what the downstream effects for the public might be in terms of compromised data, compromised agency operations. I mean, think about the drastic cuts to agencies like Social Security, the Social Security Administration, and the effects that might have on the distribution of Social Security checks. So this is information, a lot of it we would not know were it not for the sort of information producing function that unions perform. They've also been lobbying Congress on issues related to the federal workforce. They've been, in fairly intense contact with congressmen, including Republican congressmen in districts where their constituents might be affected by cuts and by the erosion of agency operations. And I think that, in the long run, to the extent that we're able to rebuild, I also think that unions are going to play an important role in helping us to recruit and retain skilled labor for government agencies where operations have been sort of degraded or halted altogether by the Trump administration. So I'll just close by suggesting very briefly that, particularly given the current posture of the Trump administration, unions are going to continue to play an important role in litigating control of the executive branch. And so it's an area that I think it's worth paying attention to and familiarizing ourselves with, because I think it's going to be strategically and legally important.
Thanks, Professor Handler. Jacqueline, Matt, any questions?
We have a couple submitted questions, and if anyone in the audience has a question, please raise your hand and we'll try to get to you. One question we have is, are federal employees still subject to being fired, as in the Patco case, if they strike?
I suppose I'll take that one. So you are not. You are prohibited by federal law, and always have been. From federal workers are not allowed by statute to go on strike, and so that was the Patco strike. Is a super interesting story. It was a wildcat strike. It wasn't authorized by the union, but they went on strike anyway. It was actually influenced by kind of like an earlier strike by the U.S. Postal Service, which was also illegal, 10 years earlier, but they sort of won concessions from management. But yes, federal workers cannot strike if there is an impasse over some workplace issue. If it arises out of an existing contract, it's supposed to go to arbitration. If the parties are negotiating a new contract and they can't reach an agreement, it goes to sort of a body called the Federal Service Impasse Panel. But disputes between labor and management have to be sort of channeled into these existing adjudicatory structures. You cannot, it's illegal to strike. And that has always been the case, and it continues to be so. And in fact, not only could they all be fired, but their union can be decertified, as happened in the Patco case.
Can I ask Shalev a question? Of course. I thought your remarks were great. So my little thing that I'm worried about, like you can't get after the subordinates, is just sort of like item 16 on your 15-item long list of bad things flowing from this expansive theory of exclusive presidential power. So I agree with that framing. And I was thinking about your two possibilities of what to do about it. So maybe this is a turn on the first one, and I just wonder what you think. One way, the court would need to do this, or we would need to proceed on the assumption that the court would endorse this whenever it gets back to it, is basically to tell them that they're doing it wrong. It may not have to entail an abandonment of this sort of categorical formal approach. But so I think about like just the difference between, say, Zivotofsky and the Trump immunity case. As you point out, like it's one thing to say the president exclusively has a particular power, then Congress exclusively has another power, right? Only Congress can regulate commerce among the foreign states, with foreign states. President can't do that. At least in Zivotofsky, it seems to me that you could read that opinion as saying more than that, as saying, the president alone has the recognition power, and that power can't be exercised effectively if Congress is allowed to do this sort of thing. That maybe this is sort of underscoring that there's exclusive and there's preclusive, and preclusive needs to do separate work. I think that this kind of approach is roughly how I recall Marty and David Barron approaching questions of the commander-in-chief power. Like only the president is the commander-in-chief of the armed forces, but whether that means that Congress is disabled from statutorily limiting what kinds of military force can be used in what kinds of circumstances is not answered by just saying that the president exclusively. So exclusive is one thing, preclusive requires maybe even a kind of functional analysis, maybe built into it. And I wonder if that might be maybe a version of your first solution or something, but maybe just as a matter of tactics, maybe easier to sell to this court.
Yeah, so, okay, great. I never managed to turn that off. Yeah, so I mean, I guess my reaction is, I think that is a way to go. It's maybe the best way to go. I just don't think it's formalism. So it's like, it's packaging a rejection of their ostensible commitment. I call it ostensible because I don't think they adhere to it, even if they think they do, to rules derived from the original meaning of the Constitution. And so the Zivotofsky case is I think that's a perfectly pragmatic way to think about it, which is the president's power over recognition includes his ability to determine the territorial boundaries of foreign states. And he can't effectively exercise that power if Congress can force him in an executive branch issued document to actually contradict himself. But that's, that's a functional analysis of like what the entailments are, or what effective recognition is like. And so that's why in thinking what I've tried to do about formalism is try to take it seriously and accept its premises and see how it works out. And that's why I come to the conclusion it doesn't, because if you take it seriously, I don't know how to draw these lines, and that's my concern. So like collective bargaining seems like like giving those rights seems to me to interfere with the full full control over the executive branch. Should Congress not be able to do that because of that? I don't think so, because Congress obviously, as I said, obviously interferes with the president's control over execution of the law all the time in ways that everyone agrees is okay. Part of them because they're directly in the text of the Constitution, like appointments. But part of it is necessary and proper to appointments. Necessary and proper to creating offices by law is that you can create departments, et cetera. And so I feel the same way. It's just like a matter of degree, but I think probably as a matter of tactics, it's got to be right that the way to approach it would be to not ask them to say that they've been wrong for however long, but to actually say that, no, this is a, refinement of the formalist method that everyone, that's one response from a formalist to me giving a paper on what I call the limits of formalism was, well, everyone's always a little bit formalist and a little bit functionalist. And it's like, correct, just, you never write that in your papers. And the court never writes that in its decisions. But so, maybe we could convince them that actually they've always been engaging. They come to their formalist rules through pragmatic analysis. And I don't really have a problem with that per se. So I hope,
right.
Yeah.
That part of it would be inevitably functional because that's all you're doing.
Right.
So my question is, I think for Shalev, based on your interesting observations about limits on executive power, even if we were to concede that there was an area that was exclusively for the executive, the idea being deliberation and information gathering, and there's sort of process values I like, and so I'm warming to that. But then I was thinking about immigration law, where of course there's plenary power doctrine, giving lots of power to the political branches, and then in particular some of the doctrines around barring non-citizens from coming into the United States. And I'm thinking Trump versus Hawaii, the travel ban case, where the court said, well, there has to be a bona fide and facially legitimate reason for barring people. But boy, were they willing to give a pass on looking any further than that like millimeter thin explanation, right? And then a second example would come from last term with the Munoz case involving consular non-reviewability, where consular officers are allowed to bar people from coming in. And that case, there was a little more information revealed about it, and they had barred an individual from coming to the US who had tattoos because they thought they were gang tattoos. And there's at least a good possibility the guy looking at the tattoos just didn't know what those tattoos represented and got it wrong. But that wasn't going to be, the court said basically, we will never look behind that decision. So I'm just curious, are those like, you would want more there, or how do they fit into your theory? Or is that an example of, boy, when the executive has complete discretion, they get complete discretion?
Yeah, thanks. So I think that's a great question. And I think it puts pressure on a distinction that I didn't draw clearly in my remarks. So I think that to me, I feel pretty strongly that the president is under these as internal legal obligations. And then there's a separate question of how the courts are going to go about enforcing them. I think with Trump versus Hawaii, for example, I completely agree with your characterization that basically they weren't willing to go a millimeter below the explanation substantively. However, they did, when in upholding the finding, so, the statute says the president has to determine that, or find that the entry of certain classes of non-citizens would be detrimental to the interest of the United States. And in saying that the president had fulfilled that function, they do spend some time explaining all the deliberation the executive branch went through. And recall it was the third version of the travel ban. The first two were enjoined, and it was different. The third one was different than the first. There are different countries on it, and so I view that as some actually support for the deliberation requirement. So like they talk about the worldwide interagency review multiple times in the opinion. So that's my positive spin on it. The negative spin is like, what did that get us? Not much, and because they did just uphold it. But I do think it's better than nothing, and I think the third travel ban, for all its flaws, was better than the first. And so that might be the best I think we can do. But I do think there's real pressure, and I think the biggest hurdle to my argument is the court going to enforce this? And there's lots of language saying they won't, but then there's also a good deal of practice, I think, that they do. And so that's kind of the world in which I think it has to operate.
Can I just add on that? I think the Trump travel ban case, as ultimately decided by the court, is a nice illustration of this. And as cases come to the court in particular, a kind of question that's going to hang over maybe all of it is the limits of the so-called presumption of regularity, and what happens when the presumption is rebutted. The presumption of regularity gets repeated by the court always positively because the presumption is always indulged. And it's a reason why the sort of process investigations by the court into what the executive branch, how it made a given decision, are relatively limited, or they're charitable insofar as there's some ambiguity in it. So obviously, I totally agree that Trump versus Hawaii stands for the proposition that the court wanted to be able to observe a certain level of process in order to conclude that the third travel ban could be adjudicated without thinking that it was utterly tainted by the problems of the first version of the travel ban. But that, you can generalize this question about process and about what does the court think about the kinds of fact patterns that would be sufficient to rebut the presumption of regularity, and what does judicial review look like on the other side of that? Because irregularity, I don't mean to be, trifling about this, but the irregularity of a lot of the executive action of the first 2 months of this new Trump term is, in the eyes of those who are involved in these actions, a feature and not a bug. It is intended that our ordinary way of conducting government be upended, and I think the court's going to run into a problem on that front, because its sort of institutional posture writ large vis-a-vis the executive branch is based on an assumption of regular order. And so I think we don't know what will happen, but I think we're liable to confront that. The courts are liable to confront that to the extent that they're reviewing this.
Time's up. Time's up. Let's thank our panelists.
The 13th Amendment, the 15th, the 19th. We can do that, but we have to be honest about what it really says and why. That's originalism, and you don't know those stories, and you need to know those stories. Okay, you need to know not just what it says, but why it says these things, and that's going to help you understand. I'm not so into form versus function. I am into purpose and spirit, and I need to know not just what the rule is, but the concept behind it. I'm very much into structure. And those things actually, I think, may help us resolve some of the tensions between form and function. Okay, so I said a little bit about birthright citizenship. I want to say a little bit more about that because that's what's closest to my heart. Amanda says, and Vic said, even if I were wrong about the Constitution, and I don't think I am, but if I were, there's a statute passed in 1940, and it's amended in 1952, and it's based in part on judicial case law, definitive, the gloss of Wong Kim Ark, okay, and this thing is internally contradictory, and it shows no evidence whatsoever of any deliberation of any sort. It's just pulled out of, the presidential, can I say it? I'll say it nicely, backside. That is the biggest constitutional assault we're facing. Now, there are other things. I actually think Humphrey's executor, well, you could argue it one way, you could argue it the other. I'm sympathetic to the idea that there's a big distinction between cabinet heads and independent agencies. And if you want to hear some of the reasons why, you could listen to podcast episodes. 2 of the last 3 are all about that with Steve Calabrese, who is the preeminent scholar of the Unitary Executive. He wrote a book called The Unitary Executive. He's the co-founder of the Federalist Society. He's the national co-chair of the Federalist Society, and you'll hear both sides. You could read his book, and you should. You could read chapters 7 and 9 of America's unwritten Constitution, which explain why independent agencies might very well be different than single-member cabinet heads. And I said that before Saylor Law. And I said that before PCAOB. And I said that before Judge Kavanaugh said some of these things on the DC Circuit, because, and I'm not making stuff up, I'm reading the Constitution, and you need to too, and I'm paying attention to the early glosses, and you should too. And we can all do this together, okay? And that's, we have to keep each other honest. We have to keep the Supreme Court honest. Now I'll say one more set of things, and then I want you to jump in. Since Trevor talked about the Trump immunity case, that case was a disgrace. It was the worst case of my lifetime. It made the Constitution itself unconstitutional, and I'll prove that to you in about 3 minutes, okay? Because what it said is if a president pardons someone, you can never prosecute them. I'm saying, WTF, why the face? I mean, what are you talking about, okay? Because when you read it, it's true, it says that the president has the pardon power. It also says, as clearly as words are capable of expressing anything, that, well, I'll read it to you, and you're going to read it yourself tonight. This is how Article 2 ends. The impeachment provisions are scattered throughout the Constitution, but here's the end of Article 2, which is the presidential article. The president, vice president, and all civil officers in the United States shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors. Bribery is obviously impeachable. And of course, if it's and the president is impeachable, and of course, the central case, the paradigm case, is bribing the president. And what are you going to bribe him about? His core presidential powers. If you bribe him to pardon you, if you bribe him to veto a law, that's obviously impeachable. And the text is clear, and I promise you the history is clear, and I spent years of my life studying it. And then what does it say? It says, once you've been convicted by the House, impeached by the House and convicted by the Senate, it says about as clearly as it's possible to say that the party convicted shall nevertheless be liable to and subject to indictment, trial, judgment, and punishment according to law. After that, of course you can be tried by a criminal court and convicted. Now, that's not the only scenario that can lead to conviction, but it's showing you as clear as it's possible to imagine that you can be convicted of doing something that the Constitution allows you to do, but if you do it for a corrupt reason, if you do it for a bribe, and motive does matter very much, of course you're impeachable, and of course you're subject to criminal sanction. They just made the Constitution itself unconstitutional in the Trump immunity case. They pulled that out of their, shall I say it? No, I won't. Their backside, okay? It's just as much an astonisher as Dred Scott, and you won't know that unless you actually know what the Constitution says. You have to read it and then reread it and then read stuff about it. And you can meet people on all sides. You're smart. You can judge for yourself. And so that was a disgrace. It really was. And here's the final set of points. We're going to have elections, but they don't mean anything if people don't judge our elected officials against the Constitution. This House is not going to impeach Donald Trump. It's not going to push back against him because it's a two-party system. You say, where's that in the Constitution? I say, actually, read the 12th Amendment and read Chapter 10 of America's Unwritten Constitution, which is about our two-party system, which is a deeply entrenched feature of America's unwritten Constitution. Okay, so House elections are going to be important, and it will matter tremendously whether it's the president's party or an opposition party. And if it's the opposition party, don't be shocked if he's impeached for a third time. Maybe not convicted, but impeached for a third time. And Senate elections are important, and who's on the Supreme Court is important, but that depends on who's on the Senate, which depends on your voting, and whether, and now, at the end, we scholars were so damn mealy-mouthed sometimes. Oh, what will, Amy Coney Barrett buy, and, what will Kavanaugh go for, and John Roberts? Damn it, they work for us. This is what we judge them by, and if they get it wrong, their reputations, we're all going to be dead soon enough, okay? And so what we have to do is insist that when people follow the Constitution, actually, we remember their legacy and we say nice things about them. As I say nice things about my friend Ken Starr, I disagreed with him about certain things, but he actually loved the Constitution with a passion, and at least he tried to actually always be faithful to it. We all fail, self included. And when they get it wrong, the only thing that actually will work is if we hold them in low regard and we insist that actually on their tombstone, on the day that they died, we're going to remember this, and I'm going to tell you forever, Tawney was horrible, and Dred Scott was horrible, and Abraham Lincoln should be your guide. That's what actually keeps the system on. And if you don't like the Constitution, let's amend it. It's got ways to amend it, and that's what brings us together as Americans. So we're going to have elections. That's a guardrail. We do have a free press. That's a guardrail. Even if they try to go after this person or that person, wow, it's so much more robust and wide open than in most places around the world. I want to end with one thing that my friend Trevor said quite brilliantly, but not today. He wrote an excellent op-ed with Rick Pildes in the New York Times in which he said, okay, here are the checks. There's Bob Woodward in the press. That's what brought Nixon down. And if you want to ask questions, I'll explain to you how it was really the press and not the Nixon court, in isolation that brought Nixon down. It was the threat of impeachment, because he could have rescinded the regulation. Regulations have the force of law. We just heard that again and again and again from Blake Emerson, but the regulation could have been rescinded immediately, and the special prosecutor in that case could have been fired, Jaworski, and then the case goes away, and none of that happened, even though legally. He could have pardoned them immediately, the defendants in the Nixon tapes case, and he didn't, because it would have been impeachment in 3 moves because of Bob Woodward and the press, and the American people were paying attention back then because they read newspapers. Okay, so I've told you there's the check of congressional oversight, which will be very big if the House switches hands and Senate oversight. There's the check of elections and the people. There's ultimately a court, okay? But here's one other thing that Trevor said, which is really interesting. So in Constitution Rock was invoked, I think maybe by Marty or other people, okay? But in Constitution Rock, Constitution 101, the administrative state is a little bit problematic, truth be told. So, but he said, in addition to all those checks, the press, congressional oversight, House, Senate, judiciary, judicial review, some of the internal checks within the executive branch, independent agencies, other folks, maybe even employees at a lower level, civil service. Trevor said something really brilliant that I hadn't seen quite before, and it was excellent, Trevor, it really was. Markets, okay, immediately were present to defy a Supreme Court order, which has not happened in American history. The market's going to plunge immediately, and that's going to get people's attention in Congress because they have to run for re-election. And if your stock portfolio goes down 20%, that'll get your attention, and then you're going to call your congressperson, and then there will be immediate effects of all that, and the dollar will drop. Very interesting. Why will the dollar drop? Because that doesn't happen all around the world when people defy court orders and all the rest. It drops because it's not baked into the price today, because actually we don't do that in America, in fact. And if we did, if we became that irregular, the prices would drop dramatically because we would be doing something that Lincoln never did, that Washington never did. That's why, because it does happen in Argentina and Venezuela and around the world. So we are an exceptional nation in certain ways. Lincoln held an election fair and square, even though he thought he was going to lose. And he held it on time. And you were taught he defied a court order in the ex parte Merriman case, a Supreme Court order. He did not. Noah Feldman is wrong about that. You were taught that Andrew Jackson said, John Marshall has made his decision, let him enforce it. He never said that, and he never defied a court order. No court order actually issued in the Cherokee case. But, you need to read the damn books, because I said all that long ago, okay, because facts are facts and they're important. Here are the key facts. Trevor mentioned Youngstown. people of the president's own party on the Supreme Court ruled against him in a time of war, and he obeyed. And in the Nixon tapes case, people of the president's own party ruled against him and he obeyed. Those actually are I'm not making that up. I'm not hallucinating. This is still America. And that could change on our watch. And if it does, shame on us that we let it happen. But the markets will drop, Trevor and Rick predicted, immediately. And the chiefs of staff will notice this and everyone else because that's not baked into the price. So I really thought that was a brilliant point, Trevor. And tell our friend Rick, too, that we gave him a shout out. Okay. I went on a little too long. My apologies. Have at me, please. Matt, you want to take your microphone around and see if anyone has some pushback? Your parents are, at a certain point, so okay.
I had Professor Pushaw last year, and I asked him a similar question, which was, have things looked as bad as they have now? And then he was like, yeah, there was a civil war thing that happened.
Yes, that is true.
So I think a lot of what you were saying—
And that's sobering, that there was a civil war.
Very. So I guess the question is the Constitution, Guardrail 1, We the People, Guardrail 2, forgetting the exact Federalist paper, I have a bad memory. Also, a few James Wilson opinions are effectively saying, yeah, we the people created the Constitution. We the people have the right to dissolve the Constitution, usually by appeal to the sword. So I guess the question—
Not so much by appeal to the sword. They did not believe that at all. They believed in legalizing revolution through amendment. And state constitutions, they're even easier to amend. California, notoriously easy. So no, they weren't envisioning future appeals to the sword. They were so damn proud that they actually launched a constitution peacefully. That's the first paragraph of the Federalist #1, that we're going to do something that no one else in the world ever did. More people got to vote on the Constitution than it ever got to vote on anything significant in all of human history. It's the Big Bang, the hinge of history. And let me just tell you one thing. So yeah, it was very fraught in the 1850s and early 1860s, and the South didn't abide by the rules. But when the Constitution was launched, it passed by this much. It passed by a vote of 30 to 27 in the New York Ratifying Convention. And you might say that's a 2-vote margin. It's actually a 1-vote margin for some technical reasons I won't go into. It passed by this much, and yet the losers acquiesced. They didn't stage an insurrection, and the winners listened to the losers because the losers had legitimate objections, and the winners listened to the losers, and they came together, and we call that the Bill of Rights. It didn't come from Madison's head. He actually was opposed to a Bill of Rights at Philadelphia. He listened to his fellow citizens, and here's why he did. Because if he didn't, he wasn't going to get elected to his House district, and if he didn't do what he promised, he wasn't going to get re-elected to his House district. So, wow, that's an object lesson. Fierce debate about the Constitution, very close. The losers acquiesced, the winners listened to the losers, and they came together. Now, I want you to know all the details of that story because that might be helpful today. And that would be chapters 6 and 7 and 8 of The Words That Made Us, which is the prequel to Born Equal, which tells you the historical story of the Constitution from 1760 to 1820. So I would say, oh, the Constitution, the American Revolution was quite fraught, and that was an appeal to arms. The Constitution, the ratification was fraught, and that was peaceful. The Civil War was fraught, and once again, alas, it was an appeal to arms because some people didn't listen to Lincoln.
So today, where Lincoln's dead.
He is.
Unfortunately.
But he can live in our hearts and our minds, and you need to know him backwards and forwards and sideways. And I aim to introduce you to Abe Lincoln. Here's what I say on that. It's just because you don't know Abe Lincoln. Here's what I want to say because you don't know what yet. Honestly, the tradition to which you are an heir, because actually we've stopped teaching history in high schools.
For sure.
So let me actually tell you what I actually say about Abe Lincoln and the conclusion of this book. And this is American. If this is American exceptionalism, So be it. We are an exceptional nation. You know, we're based on birth equality, on soil and not blood, and we're all born equal. And here's what I say about Lincoln, because and the book is dedicated to Abe, and also to Harriet Beecher Stowe, and Frederick Douglass, and Elizabeth Cady Stanton. And just to repeat, you can order it tonight if you like, and if you don't, that's fine. You still have to read it. There are libraries. I'm glad people didn't laugh. That was very kind of you. Here's what I say. This is in the conclusion. I challenge naysayers to identify any major political figure in post-1800 American politics, heck, in post-1800 world politics, who was better, net, all in, either as a leader or as a human. Don't compare Abe to Christ, although many did when he died. Compare him to Thomas Jefferson, Andrew Jackson, Daniel Webster, Stephen Douglas, FDR, Ronald Reagan, William Pitt the Younger, Queen Victoria, William Gladstone, David Lloyd George, Winston Churchill, Margaret Thatcher, Otto von Bismarck, Konrad Adenauer, Angela Merkel, Napoleon Bonaparte, Charles de Gaulle, Simon Bolivar, Benito Juarez, Jawaharlal Nehru, Golda Meir, Nelson Mandela, or anyone else in the last 225 years. No modern country has ever produced and then picked as its supreme leader anyone better than Abe. So we did that once. I want you to see how that happened and imagine, well, is it possible we could do it again? We actually launched a constitution of a sort no one in human history ever had, and these were both in polarized times, you see.
Overarching though, if the Constitution as a guardrail depends on we the people, how do we the people protect the Constitution when there would be a coalescing between the parties that are tasked to protect it intend to give up on it? So how do you do that without an appeal to arms? I mean, because
Well, you have to vote them out.
Say that they
and if you say both parties suck, I say they do, but they're not actually a conspiracy against the Constitution. I just deny your premise. You know, so I'm a Democrat. I'm very disappointed in my party. You know, I'm very disappointed in the other party, and our system does require a healthy two-party system. It's going to be far more healthy if people understand they will win if they're true to the Constitution. And they will only understand that if voters make them understand that, and that begins with you and the voters actually knowing the Constitution and voting on constitutional principles.
And there being elections.
And so far there have been, you know, so you know, I think you're declaring defeat way too soon. We're not there yet remotely. And you're letting yourself off the hook a little too easily, because actually this will depend on you and your friends, this generation, actually showing up as previous generations in American history have. And if you don't, it's the fault of my generation too, for not actually instilling that in your generation. We are always one generation from barbarism, where actually the core meaning of a constitutional provision could just be, you know, rationalized away, saying, well, maybe subject to the jurisdiction means this, or maybe it means that, or whatever, you know, Elon Werman or Randy Barnett or Donald Trump just pulls out of their backside. And when they do that, we must actually say, no, 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 hell no. It doesn't say that at all. Lincoln died for this. He did.
Akil, I'm inclined to say, preach it, brother.
Oh, my friend Mark Scarberry, yes.
Yeah.
I'm sorry, I didn't see you. Otherwise, I would have mentioned you and Shelley and Ken and, you know, all my old friends.
Thank you so much for being with us. But my friend Sandy Levinson and others say the document is so flawed.
Yes.
We should not respect the document. That's what they say.
I love Sandy, and he's my co-author, and he's reaping, you know, the whirlwind now.
I'm a naive textualist. History and tradition, sure, your books, let's add them in. But it says what it says.
It does.
And if it's unjust, change it.
Yes.
If DC doesn't get a voting member in the House, amend the...
And your testimony on that was outstanding, my dear friend. And he's a Republican, and I'm a Democrat, but we play by the same rules. Yes, I agree with you.
But then I have friends on the right, sort of you might call them Christian nationalists, who think the Constitution is the Bible, and it's almost as though they treat it as holy scripture. And that is so frustrating and dangerous too.
I agree.
Thanks so much.
Thank you, Mark. Let me actually tell you about the dedication. I apologize. This is an infomercial for my life's work, but my life's work has been in the service of the Constitution and my fellow citizens. I'm a virus, okay? I'm like COVID. I have to spread. I have to get actually into a human host. That would be you all, and get it and get into your your system, and then you have to cough on other people. That would be a 5-star review or whatever, and then we all have the measles. Okay, so so here are the books. Just the America's Constitution, a biography, and Bob, one of your students actually asked me to autograph it, so thank you for assigning it, walks you through the written Constitution from start to finish. That's textual. America's unwritten Constitution reminds you that there are non-textual, because we have to go beyond just textual formalism to make sense of the whole thing. And America's unwritten Constitution talks about how to do constitutional law while be faithful to the text while going beyond behind it. Now I'm trying to tell the chronological story of America. The epic Homeric saga of the American people over 240 years. Volume 1 is the words that made us. It's a pun, the U.S., how we, the people, become a we, and it's 1760 to 1840. We're not a we at the beginning, we become a we. Volume 2, which is out soon, Born Equal, is this idea of birth equality with the Civil War and its amendments ending with women's suffrage. And Volume 3 is called Earth's Best Hope, and it's about the last century. But here's actually the dedication, Mark, since I'm here at Pepperdine, to the words that made us. It's dedicated to 5 people, and I want to tell you the backstory behind the dedication. This is a Christian school, with by tradition. It's affiliated with the United Church of Christ at Yale, and I'm comfortable with that myself. But that can't be America. America is not a Christian nation; it's an inclusive nation. So here are the dedicatees of that first volume. This book is dedicated to Lin-Manuel Miranda, Vanessa Nadal, Ron Chernow, Kaiser Khan, and of course to Neil Kumar Katyal, who introduced me to each of you. Thank you all jointly and severally for helping me and so many others to see the true meaning of America. Here's why I picked them, okay? I happen to be an adult convert Protestant, but Lin is born Catholic, and so is his spouse, Vanessa. Kaiser Khan is a Muslim. He very famously held up a copy of the Constitution. He's a Gold Star father who lost his son, in a war for all of us. Neil Kumar Katyal is Hindu, as my parents are, and we are all Americans. We all love America. So you're allowed to be a Christian. You're allowed to be a nationalist, a patriot. I hope you are a patriot. But you have to understand that America isn't about being born Jew or Gentile, black or white, male or female. It's being born an American. Your parents next? Oh, okay. Yeah. This is Matt's dad, right?
Yes, correct.
Okay.
As a layman, I'm not a lawyer. Do you feel that...
Truthfully, I'm not either. I never took the bar. Now he tells us, okay.
Do you feel that this birthright citizenship can be abused at times?
Yes.
And if yes, what is the remedy?
Go after the parents. You can fine them. You can criminally punish them. Amanda talked about all sorts of things you can do. You can go after employers, which Marty said, and follow the money. But you cannot visit whatever misdeeds, if misdeeds they be, may have been committed by the parents upon the children. That's a deep American principle. When you read the Constitution as a whole, we don't have titles of nobility. We don't have corruption of the blood. We have a deep idea. And Vic highlighted this very much in his remarks. Whatever the parents may have done, the kid who's born in Ann Arbor, Michigan, is born an American, black or white, male or female, Jew or Gentile, gay or straight, in wedlock, out of wedlock, to citizen parents or non-citizen parents, legally here or not. It's about the kid. You can say the kid can never sponsor the parent 20 years later. You can do lots of things about the parents, but the kid is born an American. And if you don't love that, let's amend the Constitution. We've done it many times in the past, but then there would need to be a consensus to get it out. There was a consensus to put it in. What's hard to do should be hard to undo. I'm guessing that you two have been married a while. Okay, my wife and I have been married for 35 years. What's hard to do should be hard to undo, and marriage is not to be, pastor told us, is not to be entered into lightly, and so we put this thing in. It was very hard to put in. We should be very careful about pulling out, and at a minimum, you want to know why it was in there, not just what it says, but why. What were the problems with the regime before that? Because I promise you, if you go to Germany, here's a problem in Germany. There are, they're called ethnic Turks. There are 3 generations of people who've actually been born in Germany, but if you go back long enough, you see one of them wasn't there legally, or this is what Amanda was saying. Every generation, see, our system pushes a reset button. It doesn't matter what your parents did, or your grandparents did, or your great-grandparents did. That's a source of national strength as well as weakness. But unless you know not just what it says, but why it says these things. And I want you to read Amanda's books on this. And I want you to read Jerry Newman's stuff on this. Then if we want to change it, we can change it. Other generations have changed the Constitution, and so can we. But that's why and this is not formalism narrowly, it's not functionalism, it's purposivism. We need to know why earlier generations did what they did.
Thank you.
Thank you. My question is about originalism. You talked about it before,
Yes.
and you mentioned that if a case is wrongly decided, it's the court's duty to overrule it.
As a general proposition.
So what is your view generally on the concept of stare decisis? Is it even constitutional? Is it
Yes. And it's chapter 5 of America's unwritten constitution, and I'm glad you're not laughing, because these are serious questions, and I've tried to address all of them systematically. It's called putting precedent in its proper place. And I talk about 5 or 6 ways of thinking about precedent. First of all, there's vertical precedent. Even if a lower federal court judge is is smart, maybe smarter than the justices, let's call him Kevin Newsom, or let's call him Amul Thapar, or what, I could pick people on, let's call him Shri Srinivasan, let's call her, Nina Pillard. We could, even if that were true, they're on an inferior court and they have to follow Supreme Court precedent. And the person who didn't do that was Steve Reinhardt, who sat in this city, and Vic and I criticized him savagely because, he actually was obliged by the rules of stare decisis to follow what the Supreme Court had said. And they can overrule themselves. At the Supreme Court, precedent is often a starting point, a default rule, and you have to prove that it's wrong, because you can't reinvent the wheel every time. And Trevor said that's true of OLC opinions. They don't start from scratch every time. They start with a presumption that the earlier opinions of the institution, whether the OLC for the executive branch or the court, they sort of start with that, and then they do overrule themselves sometimes and modify, but it's a starting point. And more than that, and Trevor said this too, and I think Marty would probably agree, and they've worked it in OLC, it's not just a starting point, but it's an epistemic weight. You want to think 3 times before you overrule this, because earlier people actually thought the contrary, and you want to make sure that your initial reaction wasn't mistaken. You have to think about certain reliance interests. I go through a framework of analysis about how to think about stare decisis. A lot of times, the precedents actually aren't about the Constitution, they're merely about a statute, and when it comes to statutes, we basically say the statute typically bears the gloss put on it by the case law, and if you don't like that, just amend the statute. It's easier to do. There are lots of maybe the precedent isn't a constitutional precedent, it's a common law precedent. Maybe it's not about constitutional meaning, but about constitutional implementation. And so chapter 5 of America's unwritten constitution walks you through the ways to think about stare decisis once you understand the key point, that the supreme law of our land is not Supreme Court case law. It's the Constitution itself, full stop. And if statutes that are inconsistent with that must go, as a general proposition, that's called judicial review. If administrative regulations that are inconsistent with that must go. If Trump orders inconsistent with that must go. I think the same thing is logically true of Supreme Court case law that's inconsistent with the Constitution, and we call those Dred Scott and Plessy being, basically abandoned by Brown, and Lochner being abandoned by the New Deal Court, and the Warren Court overturning lots of precedent in the name of the Constitution, and the Barnett case overruling Gabaitis, that's precedent on precedent itself. You see, that's meta precedent, saying when the precedent is wrong, our ultimate obligation is to the Constitution. As a general proposition, there are all sorts of subtleties and wrinkles here. And the burden of proof, I think, rightly falls on someone who's saying the precedent was wrong. They have to show, why it's wrong. And so it's a starting point in an epistemic weight, even at the Supreme Court. And there are reliance interests that must be factored in.
Thank you.
And that's, we'll have podcast episodes on this, but that's also chapter 5.
We have time for one more quick one from our incoming editor-in-chief, Mitchell Brost.
Congratulations, Mitchell.
Well, thank you, Professor. And
You
thank you
have,
also.
you have very big shoulders to, very big shoes to fill.
That is for sure. I was wondering, just given these textual guardrails, we have election process, impeachment, constitutional amendment. It seems that the Constitution assumes good faith compliance with the results of those processes. So what do we do when there isn't that sort of compliance?
And that's why I do want you to read. I thought Erwin Chemerinsky had a thoughtful piece in the New York Times, and those who remember actually Erwin in this space, with me on previous occasions, will recall that I don't always agree with my dear friend Erwin about all sorts of stuff. He used to be, here in Southern California. Now he's in Northern California. He wrote a thoughtful op-ed about this, but and he says the Nixon tapes case, actually, President complied with it. Youngstown steel seizure case, Truman actually complied with it. By the way, I said those same things 2 weeks earlier on CNN with Pamela Brown and Wolf Blitzer. But here's what Trevor and Rick added to some of that. They said the markets are an important check on all of this, actually. And they will react immediately to something as massively irregular and un-American and unprecedented, I would say, as presidential defiance of a Supreme Court order. Lower court opinions, non-acquiescence, that raises some slightly different concerns. So there are complexities. But I'm looking at my friends, Marty and Trevor especially, and Vic, and anyone else who wants to chime in. Has there ever been a Supreme, and I want you to read Will Bode's outstanding article in the Georgetown Law Review. It's called The Judgment Power. But has a president in American history ever openly defied a Supreme Court order? I don't think so. And someone who said that they did is Noah Feldman in his book, The Broken Constitution. Don't read it, or read it and read my refutation of it, okay? Because facts are really important and we got to get them right. So I thought that Trevor's piece and Rick's piece was really interesting because I really hadn't fully appreciated how much free markets as well as a free press and free elections combine to create a guardrail system in America.
We're going to have some concluding remarks by Jacqueline Kessel, the editor-in-chief.
Thank you, Professor Amar, for your brilliant remarks. We very much appreciate you coming today. Good afternoon, everyone. As we conclude today's symposium, The Future of Executive Power, Can Congress and the Courts Check the President? I want to take a moment to reflect on the incredible discussion and scholarship that we've witnessed. This event has brought together some of those most distinguished minds in constitutional law to engage in a critical dialogue about the evolving role of executive power in our democracy. At Pepperdine Law Review, our mission is to provide a forum for criticism and development of the law. Events like today's symposium exemplify that mission. Our esteemed panelists, Professor Amar, Emerson, Farber, Frost, Handler, Liederman, Morrison, and Weissman, and of course, our keynote speaker, Professor Akhil Amar, have provided timely, thought-provoking, and transformative insights that will no doubt continue to shape the legal discourse around executive power. Thank you. I would also like to express my deepest gratitude to our moderators, Professors Hoops, McDonald, and Pushaw, for their invaluable contributions today, and our faculty advisors, Professor Johnson and Professor Pushaw. for your hard work, patience, and flexibility, and mentorship to Matt. And this leads me to a huge special thank you to our symposium editor, Matt, whose dedication and leadership were instrumental in bringing this event to life. I've watched you dedicate your time and energy to this event for the last 9 months, and I can say that the next year's symposium has a high bar to live up to. We couldn't be more proud. We're also deeply grateful to Professors Daniel Farber, Trevor Morrison, and Vikram Amar, who have graciously agreed to contribute articles or comments to next year's symposium issue, which will be featured in volume 53. Their scholarship will ensure that today's discussion continues to inform the legal discourse around executive power. Thank you all, and thank you all, our attendees, scholars, students, and practitioners, for your engagement, your questions, and your participation in this critical conversation. Safe travels, and thank you again for being part of the Pepperdine Law Review Volume 52 Symposium. We're grateful that the guardrails helped you make the journey.